I think we'll go ahead and get started so we can stay on time. I'm Sally Ryder. I'm director of the Rehnquist Center here at the Rogers College of Law. On behalf of the Law School, the Rehnquist Center, and the Tucson chapter of the Federal Bar Association, welcome to the 10th Annual Constitution Day program. For those who don't know about the Rehnquist Center, the Nonpartisan Center was established in 2006 to honor the legacy of Chief Justice Rehnquist by focusing on structural constitutional issues. So today's program's a natural fit. We have a great panel, but before I introduce them, I'd just like to talk about the format a little bit. We'll be discussing 4 cases today, and for each, Professor Marcus is going to give a brief summary. The panel will then discuss the case, and then we'll take questions from the audience. We've allotted different amounts of time for the cases, and we'll take a break from 2:30 to 2:40. We have student volunteers who are going to keep time for us so we can stay on schedule, honoring the Rehnquist name again. Chief Justice Rehnquist used to give an end-of-term review of the Supreme Court's work at the Fourth Circuit's Judicial Conference. And there he often focused not on the headline-grabbing cases, but on the more mundane cases that made a bigger difference in the lives of practicing lawyers. And I'm sure Judge Starr will remember that the Chief would describe these cases by quoting from Thomas Gray's elegy written in a country churchyard. Full many a flower is born to blush unseen and waste its sweetness on the desert air. Those lines seem particularly apt here in the desert air of Tucson, and I think we have at least one such case today. Now our panelists are, starting from my far right, Judge Kenneth W. Starr, who is the Duane and Kelly Roberts Dean and Professor of Law at Pepperdine University School of Law. He served as a law clerk for Judge David W. Dyer of the U.S. Court of Appeals of the Fifth Circuit and for Chief Justice Warren E. Burger, whose birthday happens to fall on today, Constitution Day. While in private practice, he was a partner at Kirkland & Ellis and Gibson, Dunn & Crutcher. And in addition to working in the private sector, he has served as counselor to the U.S. Attorney General William French Smith, judge on the U.S. Court of Appeals for the D.C. Circuit, Solicitor General of the United States, and independent counsel on the Whitewater matter. As Solicitor General, he argued 25 cases before the Supreme Court and still has an active Supreme Court practice. Sitting next to Judge Starr is Judge Neil V. Wake, who took his seat on the United States District Court for the District of Arizona in March of 2004. Judge Wake was born and raised in Phoenix, as a matter of fact, right down the street from where I grew up. He received his BA from the Arizona State University in 1971 and his JD from Harvard in 1974. Before being appointed to the bench from 1974 to 2004, Judge Wake engaged in trial and appellate practice in Phoenix in several law firms, including Jennings, Strauss & Salmon, Bryan Cave, and his own firm. He's been a fellow of the American Academy of Appellate Lawyers since 1993 and served on the State Bar of Arizona's Civil Practice and Procedure Committee for nearly 20 years. Next on our panel is our own Tony Massaro, Dean of the Rogers College of Law. Dean Massaro received her BS from Northwestern University in 1977 and her law degree from the College of William & Mary in 1980. She was in private practice in Chicago and has taught at Washington and Lee University, Stanford University, University of North Carolina at Chapel Hill, the University of Florida, and in Frankfurt, Germany. She joined the faculty at the University of Arizona College of Law in 1989, has been the Milton O. Reapy Chair in Constitutional Law since 1997, became Dean of the College in 1999, and was named Regents Professor in 2006. Finally, Professor David Marcus, who's an Associate Professor of Law here and teaches civil procedure, complex litigation, and American legal history. Professor Marcus received his BA from Harvard University and his JD from Yale. Before joining the faculty here, he was in private practice in San Francisco, clerked for Judge Aline R. Ross of the Eastern District of New York, and Judge William Fletcher on the U.S. Court of Appeals for the Ninth Circuit, and was a lecturer at Stanford Law School. Now I'm going to turn it over to Professor Marcus for our first case, which is Heller against the District of Columbia.
It's very much an honor to be included on this panel today. In fact, I'm a little puzzled why I'm included on this panel, given the obvious achievements of my co-panelists and my paucity in comparison thereof. But the intimidation that I'm feeling today is not going to prevent me from being quite biased and subjective in my presentation of the cases. So I hope that you'll be able to glean what is actually going on in these cases from my summaries. But do keep in mind that I have my own opinions of them, however uninformed and ill-conceived they might be. So let me turn to last year's term. But before that, I will invite you to think about an article that a famous Harvard law professor, Henry Hart, wrote in 1959 called The Time Chart of the Justices. Now, many of you know Hart from his famous casebook that he co-authored with Herbert Wechsler, Hart and Wechsler's The Federal Courts and the Federal System. Hart's article concerned the business of the court in the late 1950s. In 1957, the court issued a total of 220 opinions, 149 cases disposed of by full opinion. Hart, through a very intricate series of calculations, determined that each Supreme Court justice spent on average less than 24 hours per case disposed of by full opinion. His conclusion was the court was doing a lousy job, deciding too many cases, spending too little time on each, and writing opinions that really only reflected about 24 hours worth of work. As he said, quoting another keen court observer of the day, Alexander Bickel, the court's product has shown an increasing incidence of the sweeping dogmatic statement, of the formulation of results accompanied by little or no effort to support them in reason, in some of opinions that do not opine, and of per curiam orders that quite frankly fail to build the bridge between the authorities they cite and the results they decree. What Hart was criticizing in 1959 was the notion that the justices were simply deciding cases according to their own policy preferences, not in accordance with any well-reasoned legal principles or timeless rules of law, and certainly not pursuant to a reasoned and neutral process of judicial deliberation. Things have changed dramatically. Last year, the court decided 67 cases by full opinion, the fewest it had decided since 1953. To get a sense of how things have changed, I invite you to think about a very famous case from the mid-1950s, Brown versus Board of Education, a case on a very complex and important issue of social and political issue of the day, the segregation of public schools. The court disposed of Brown in a total of 8 pages. On one of the cases we'll discuss today, also a complicated case, also a case involving important issues of social and political policy, the Boumedienne V Bush case, the court uses 74 Westlaw pages to dispose of this case. Other things have changed as well. If the court in the 1950s, the court that decided Brown, paid way too much attention to policy concerns and too little attention to text, history, formal legal rules and principles, and a method of reasoned elaboration, as Hart might have called it, today's court has swung way to the opposite end of the spectrum in my mind. The opinions that we'll discuss today, with the exception of one, display an alarming formalism. With the exception of Boumedienne, I think that the court, in the 4 cases we discuss today, demonstrates a staggering indifference to facts and actual policies that the cases implicate. I believe that the justices might think they're following a pretense that they are not actually deciding, that the words of the Constitution and statutes lead them mechanistically and inexorably from legal question to legal answer. Hence, we see opinions larded up with citations to 18th century authorities, and we see opinions utterly bereft of any serious consideration of the ramifications these opinions might have for their real-world policy. I believe that these opinions illustrate a dominant and resurgent formalism in American law. So with that very biased outlook in mind, let me turn to the first opinion. I don't think any case illustrates this better than the District of Columbia versus Heller. This case is the easiest to summarize, so I'll take the shortest period to do so. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. The question at issue in Heller is quite simple. Does the Second Amendment guarantee an individual right to bear arms for any lawful purpose? Or does it guarantee a right to bear arms for purposes connected with malicious service, as the prefatory phrase might suggest? Now, I can imagine the Supreme Court justices confronted with this case salivating at the idea of writing an opinion about a constitutional amendment, an opinion on an utterly blank slate. The Supreme Court hasn't definitively encountered this question in its over 200 years of its own history. The opinion involves the District of Columbia law that was enacted in 1976 that effectively prohibits the ownership of handguns. Justice Scalia, writing for a 5-4 majority, interprets the text of the Second Amendment to guarantee an individual right to possess firearms for any lawful purpose, and he strikes down the district's law as running afoul of this right. Justice Scalia reaches this conclusion by going phrase by phrase through the Second Amendment. He invokes voluminous historical material. We see 18th century dictionaries cited, 18th century law treatises, state constitutional amendments from the same period that address the same issue. And we see throughout these materials that the original public meaning of the Second Amendment, that is, the meaning that these words had when used in 1791, the original public meaning supports an individual right to bear arms for any purpose, not necessarily purposes connected to malicious service. Let me give you a couple of examples of Scalia's methodology. For example, take the phrase, the right of the people. Justice Scalia looks at the term the people and says, well, if we look at the various materials from the era, we can determine that when the court says the people, when the Constitution says the people, it doesn't refer to a collective like a militia, but rather individuals, individual people. Another example, to keep and bear arms. This phrase does not necessarily imply any military purpose, but rather simply means that people can have and use arms for any lawful purpose. Again, using these historical materials to decode the Constitution. Now, what about the Preparatory Clause? The clause reads, the well-regulated militia being necessary to the security of a free state. The court holds in the majority opinion that we should not limit the text of a right by its preface. All the preface means is that the purpose of an individual right to bear arms is to enable citizens to join militias and thereby fight state tyranny. If we don't have a pre-existing right to possess firearms, there is no way we can assemble as a militia when the time demands. An individual right to firearms, in other words, is a prior condition to the ability of the people to come together as a militia and resist tyranny. Well, this is about it to the court's reasoning, but let me flag 3 issues. First, with respect to law, Scalia's opinion establishes an unequivocal individual right to possess firearms for any lawful purpose, or that's how I read it. But of course, the existence of a right does not mean that the right can't be regulated. That's standard for any right guaranteed by the Constitution. If there's a right, an individual right as the court holds, then certainly Dease's law violates it in Justice Scalia's mind. It amounts to an absolute ban on handguns, and that couldn't possibly be consistent with the right. But the opinion leaves open what standards courts will use to scrutinize gun restrictions that don't go quite as far as DC's and amount to an absolute ban on gun ownership. So Justice Scalia assumes, for example, that certain weapons, unusually dangerous weapons, M16s, RPGs, those sorts of weapons used for military purposes, can be regulated, but he doesn't provide a standard of scrutiny that says how and why. Second, with respect to his methodology, the Scalia's opinion, the majority opinion, is probably the most prominent example of a method of constitutional interpretation that tries to afford the text its original meaning, that is, the meaning of the words the document had as an objective matter at the time they were written. The problem, I think, is that Justice Stevens, in his dissent, writing for the 4 justices who do not agree with the majority opinion, writes an equally compelling and plausible historical account that provides the Second Amendment with exactly the opposite interpretation. I also think it's problematic that historians, not lawyers, but professionally trained historians, have come out on opposite sides of this debate. Two prominent historians, including the Pulitzer Prize-winning Jack Rakoff, believe that the court, Justice Scalia, has interpreted the amendment incorrectly as a historical matter. So with a historical record not quite as clear as the majority might suggest, can it truly be said that the court is governed by text and history, or is it governed by its reading of text and by a selection of historical materials that it can find to support its preferred policy outcome? And third, with respect to some reality, Justice Scalia says the prefatory phrase announces the purpose of the individual right, but does not restrict that right to the announced purpose. In other words, the reason why the founders included the Second Amendment, he suggests, is so that individuals can combine into militias and thereby resist state tyranny. Nowadays, as the justice himself admits, in order for a militia of citizens to be effective as a fighting force against state tyranny, that militia of citizens would have to be armed with the sort of weapons that Scalia suggests can be regulated: M16s, RPGs, tanks, nuclear warheads. What a militia would need in order to resist the full power of the United States Army. In other words, the Second Amendment has lost its purpose. But Justice Scalia says, to quote the opinion, the fact that modern developments have limited the degree of fit between the Preparatory Clause and the protected right cannot change our interpretation of that right. Let me put it more darkly. Even as the purpose of the right expires, we are nonetheless trapped by it. Now, the merits of this law, DC's law, are quite open to debate. There are ample social science research on both sides of the debate suggesting that the law does not protect against crime, that the law does protect against crime, what have you. But one thing is certain: the District of Columbia in 2006 was our deadliest jurisdiction in the United States, 33% more gun fatalities than the next closest jurisdiction, that of Alaska. This, of course, for the court doesn't matter, nor do any other facts about the efficacy or lack thereof of a handgun ban in addressing a public health calamity. What matters, I believe, is this gossamer's thread that the majority spins to weave together inconclusive and spotty historical materials. And it is on this gossamer's thread and nothing more that the court would have the fate of an American city hang. So I will end there with that melodramatic conclusion and turn it over to the panel.
Thank you, Professor Marcus. Judge Starr?
Well, happy Constitution Day, and thank you, Sally, for your work in arranging this, for your leadership. Dean, thank you for your hospitality, and to our other hosts from the Federal Bar Association. A special word of thanks to Sean Briarcliff, who told me where to park today, and that was a great blessing. Chief Justice Rehnquist, if I could, and if I'm ruled out of order, I will gladly get myself back in a state of order. But I did want to reflect for just a moment on this truly great justice, whether one agreed with his jurisprudence or not. His greatness as chief, I think, was universally acknowledged. The affection, the fondness for him, his towering intellect. I'll always remember being caught up short because of his virtual encyclopedic memory when, in the course of sort of stumbling through an argument and doing the best I could to handle the questions flowing my way, to give you a sense of the flow of questions. In my second argument in the court, someone was kind enough to tell me how many questions I was asked during the course of my 30-minute argument. I said, I don't know. How many? 63. Which prompted one wag to suggest, Mr. Solicitor General, perhaps if you had answered some of the questions, there would have been fewer, which I thought was churlish and unkind. But the chief was clearly disturbed by one of my answers. The justices frequently were, and rightly so, disturbed by my answers. But in this particular instance, I was really brought up short. The microphone, Sally, you can see this in your mind's eye, and other members of the panel as well. The microphone comes on, and he springs forward, and I'm the mouse, and he's a very large and fearsome cat. General, are you suggesting that Oklahoma Publishing versus Walling should be overruled? I had never heard of Oklahoma versus Walling. And I was supposed to be, under the statute, learned in the law. I was in a state of distress, but I knew as an advocate, emphatically not, Mr. Chief Justice. That is far removed from our submission. And I was hopeful that he wouldn't say, why? Happily, he, having made his point as being, if not the very smartest person on the court and in the room, certainly the most learned, and I don't think anyone would quarrel with that proposition. It's also good to be here because I had the honor many years ago of serving a tour of duty on the Board of Visitors of this distinguished College of Law. Now, Professor Marcus said he was not going to be terribly objective. He made a comment about staggering indifference to facts, and that is a very interesting charge to make. He notes the dominant resurgence of formalism and then really calls into question, I think, the utility of the inquiry into the meaning of the text. Because we are at a college of law where we do study text, I think it is important to note the observation of Akil Reed Amar of the Yale Law School that there has been a complete, are you ready for this? Judicialization of the Supreme Court. And Akil, who's extremely learned in the law, knows exactly what he's talking about. You see, there are no legislators there. There are no former United States senators or governors. It is a judge's court. So it's not surprising that judges are very eager to find sources of law and to suggest that if we would just turn to the facts, we would all be in cheerful agreement and we would have total harmony in the great sense of Brown versus Board of Education, and we can just all go marching to Pretoria in a state of victory, I think is wrong. There will continue to be deep differences, and so the question really is not will there be differences. The last time I checked, there were differences in religious communities of faith who turned to the same sacred text for edification. These are matters of interpretation. These are matters of judgment. And what I'd like to do is share some of the words from the opinion itself. And then you assess whether the enterprise is legitimate or not. This is Justice Scalia. In interpreting the text, we are guided by the principle that the Constitution was written to be understood by the voters. Voters? What voters is he talking about? He's talking about the ratification. Its words and phrases were used in their normal and ordinary as distinguished from technical meaning. Where does he get that? From a case. He's quoting a case that's almost a century old. And then he has a cite to Gibbons versus Ogden. Now that is lofty stuff. And I say that with the greatest of respect. Go reread, or read for the first time, McCulloch versus Maryland and Gibbons versus Ogden. And you'll see an effort to understand the history of this document as opposed to say, well, this is just a text that we will begin looking at, but of course we want to move to policy. We will be the policymakers, you see, unelected policymakers, to serve for life. Do you know when Justice Stevens was appointed to the Supreme Court of the United States? A long time ago. Most of you weren't born. He is a very venerable justice. He has a great mind, a remarkable memory, total integrity. He is extremely smart. He graduated #1 in his class at the College of Law at the University of Arizona. Well, no, Northwestern. This is a very smart man. But should he be your platonic guardian? That's a question that we should constantly ask. When one goes through the materials, I think that reasonable minds can in fact say this is a serious debate and worthy of the mighty minds that are on and serving on the Supreme Court, these judges, and that they're serious about it. In the 1980s, there was in fact a great debate over whether this kind of inquiry into the original, what is the meaning of the text, the original understanding of the text. But this is utter sophistry. It's silly. It's arrogance cloaked in humility, was the very unkind statement made by a sitting justice on the Supreme Court. And yet when you go and look at the opinions themselves time and time again, what you'll see is all the justices, even those who served as governors or as senators, were originalists. They use it. What else do you expect them to use? Now, it's not the only tool in the judicial toolbox, nor should it be. But it certainly is, in fact, whatever the Academy does, and the Academy frequently scoffs at the whole enterprise of originalism. Who in their right mind would think that it's worth 9 justices confirmed by the United States Senate and who probably would not be impeached if they chose not to engage in the originalist enterprise? I also want to make a comment about the facts. This was a very carefully designed, there's a legal practice point here. This is a very carefully constructed challenge. Remember that the District of Columbia went farther, and we're going to hear a little bit about Indiana having gone farther in the voter ID law than any other state. Terrible. Well, guess what? The District of Columbia had gone farther than any other jurisdiction. Good. Wonderful. Well, maybe not, because then the plaintiff in this case, Mr. Heller, are you ready for this? Works at the Federal Judicial Center as a law enforcement officer. He serves the judiciary. And his desire was to keep a handgun in this very dangerous community in his own home, not to pack heat to the 7-Eleven. He said, I don't want to conceal the weapon. I want to keep it in my home for self-defense. That's pretty powerful. You don't have to be a member of the National Rifle Association or approve of it to say, gosh, that seems a little bit different than United States versus Miller, which involved a sawed-off shotgun, which was not used for militia purposes or any other kind of benign or self-defense purposes at all. So I subside with this. The facts do, in fact, count. The facts of this case count. And I think we're going to see that bad facts and the bad development of the record will, in fact, at times lead almost inexorably to the outcome. We're going to see that in preemption. We're going to see that, I believe, in the Crawford case, the Indiana case. I leave you with this thought. This particular plaintiff was a sort of perfect, law-abiding plaintiff, no arrest record, who said, and no one disputed this, I want to protect myself in my own home. That's a pretty powerful fact that perhaps was significant in carrying the day. Thank you.
Thank you, Judge Starr. Judge Wake?
Well, I too thank you, Sally, and Dean Sarl and David. It's nice to be here, and I will try to share some thoughts with you that do not cross over the line of extrajudicial opinions, especially ones that could get me in trouble with actual cases. This case is a constitutional fly trapped in amber ages ago, preserved for us to look at, but dead. Now it is as though Steven Spielberg had extracted DNA from this fly and brought it back to life. So now we have a real animal, a new animal, in practical terms, a new animal in the menagerie of constitutional rights. And some people celebrate its return from extinction with the same joy that bird lovers would greet the discovery of a living ivory-billed woodpecker. And other people think this is a living dinosaur stomping through our jurisprudence. Spielberg made a movie about the Amistad case in the Supreme Court. Maybe I'll make a movie about this case. I want to offer a comment that's practical. I'm going to suggest that this case is probably going to have very little practical effect. It is an enormously intellectually interesting case because of the exploration for the first time in a centuries-old constitutional provision that pits different approaches to interpretation, whether principally historical approach or an approach that gives more weight to contemporary circumstances. But however you come out on that, and I'll have a few comments on that, I'm going to predict that this is probably going to have not great consequences. Because right now, it's just a limitation on the federal government. For handguns to be prohibited outright, there would have to be the political will in communities to do that. And I'm predicting that there are few places that are going to have the political will to prohibit the possession of handguns outright. The District of Columbia, yes, but probably few other places. If there are significant places and areas that have the political will to want to do that, then we confront the question of whether this constitutional right is good against the states, the corporation issue. And the court noted this issue in footnote 34 and was careful to point out that they were not addressing it, but that it has previously been decided more than 100 years ago. And that the old case law, to use more recent vocabulary, does not incorporate the Second Amendment into the fundamental liberties fundamental rights essential to ordered liberty of the Due Process Clause of the 14th Amendment. So that issue is going to come back. There's going to be some lawyers who are going to get another trip to the Supreme Court in the attempt to overrule the Cruikshank case and other cases that the court notes. And then we will have another exciting intellectual adventure that'll take us back to the whole incorporation controversy that's been kind of quiet in our jurisprudence since everything got resolved some decades ago. So we will go back to discussing whether the right to bear arms as protected in the Second Amendment is a fundamental right, whether it is incorporated into the 14th Amendment. Maybe we'll have discussion about the nature of that right and how central it is to our liberties. We might have some justices, as we had in the previous decades when these issues came up, who will say that everything in the Bill of Rights is incorporated into the 14th Amendment. It's the end of the discussion. The most interesting thing to me is whether that discussion is going to pay attention to contemporary social realities, whether the fundamental character of this right will be evaluated in a modern context or in a social context of 1791. Guns in homes now have a kill ratio that overwhelmingly favors friends and family over intruders. So if that fact is to be considered, a sensible society would want to give that weight in settling this question of social policy. It comes up, as I said, I think it will come up in the incorporation debate. Right now, as a practical matter, we have a constitutional right, a constitutional provision that is beyond the process of constitutional amendment. You will not get 2/3 of Congress and 3/4 of the state legislatures to tinker with the Seventh Amendment. So the court has now to tell us how wide this is going to go. I think it's a fair question as whether this will be incorporated in the 14th Amendment. I know there's already been a lot of debate about this, but it may be a constitutional right of a different magnitude from the others in the Bill of Rights that have been, most of them, incorporated into the 14th Amendment. And the court may well look at the practical social consequences of extending this right to limitation on state government. Now, I don't have a prediction. It's not there yet, but it will be interesting to see when that comes. I noticed in the opinion that Justice Scalia gave a lot of attention to this book, Joyce Lee Malcolm's To Keep and Bear Arms, which was written in 1994. I believe it's the first book-length treatise on the history of the Second Amendment and the right to bear arms in the modern era. And she makes really the case that Justice Scalia adopts in his opinion. And this is, I read this about that time. It was a gift to me from a very good friend from law school who sat in the seat right in front of me at contracts and who was also a lawyer in Tucson and a good friend of the College of Law, Sandy Froman. And I'm advertising this book because if I fall on hard times, I'm going to put it on eBay because it's a gift from a future president of the National Rifle Association. So with that, I yield.
Thank you, Judge Wake. Dean Massaro? The thing I like about Heller is they actually cited some law professors. He says that's the problem with it. David thinks it was the wrong law professors. No. Two lines of commentary. First, Heller itself. Judge Starr says that this was a great plaintiff. And, if you can't defend yourself in the home, where can you? And, of course, it is a great plaintiff, but that doesn't answer the question of whether it should be the local government who decides how to regulate that great plaintiff or if we should constitutionalize the Second Amendment in a way that disables that local community from making determinations about it. I don't actually feel, and this is increasingly the case, we were talking about in common law this morning, that if we go to take the turn to historical analysis as being dispositive, I think a lot of lawyers are incompetent to try the cases, or even to litigate them without the assistance of a fleet of historians. And I think that's probably not what the framers intended either, in terms of the whole approach to these things, that would be necessary in order to litigate or understand them. The court relied heavily on the linguist's brief. And while it's, on the one hand, Justice Scalia is saying it's really important that we look to public meaning, and I agree, and the democratic understanding of the Constitution, and I agree, and the text of the Constitution, I agree, it's rarely the case that these things are, even with all of the evidence we can amass from that time and place, self-proving. The Stevens opinion indicates the complexity of doing this, though it doesn't necessarily tell you what to do when history is ambiguous. But one fact that I think is worth noting, in that this was from the Scalia opinion itself. Scalia talks about how at the time of the adoption of the Second Amendment, there were at least 9 different jurisdictions that adopted, he said, comparably individualistic but much more specific language. And therefore, that pointed in the direction, in his analysis, toward an individual interpretation of the right. Why? If they knew then how to write it more specifically, directing the contemporary understanding to the individualized approach to it, why doesn't the omission of that language in the Second Amendment imply the opposite? My point is not that you decide one way or the other, but these things are infinitely debatable no matter whatever approach you're going to use. The day after Heller, whether you think they got it right or not, I agree that the case is likely to be of ultimate minimal consequence on the important question of gun control. I do think they're going to deem it to be incorporated into the 14th Amendment. I hope that actually they'll engage on the question of whether the right way to think about this is through incorporation of an enumerated right under the 14th, or to revisit the historically vibrant once question of whether the Privileges or Immunities Clause is actually the better home for this. I doubt they will. Justice Thomas may raise that question, but I think that is one thing the day after Heller that is going to inevitably be presented to the court no matter how they choose to decide the follow-up case of whether the states are included in the ambit. So that's one thing. Second thing, I think, we haven't talked about this, hearth and home. I mean, I read the opinion and I know why it's here, but I thought, did Justice Scalia really say that? All of the people who've studied the history of gender and the Constitution, we see hearth and home in an opinion, we run shrieking from the room. Hearth and home is material here, but it's an extremely loaded, pun intended, example. But then I thought, calm down, and I thought, okay, what he's talking about is not just the ability to be ready to oppose tyranny. That's the militia, why the introductory clause is important to understand the right. But he's also saying that this is part and parcel of a core right to defend hearth and home and self-defense, the common law right of self-defense. Okay, lawyers rush in. Why is it, now it's a theoretical matter, these things begin with law professors, but they end up in the courtroom, this idea that the Constitution, in this opinion I would cite, is relentlessly libertarian, and this emphasis on individual rights, and then hewing back to the common law right. It's almost the right to expel the individual from the home in the face of threat, even with firearms. Okay. I think that it's an interesting theoretical link to the right to expel the government in the area of reproductive freedom. I think that it's an interesting right to, it's like an action in ejectment. I think property law is an excellent predicate and embedded in both the structure and in some places the clear language of the Constitution to help us to think more deeply about how, if you're going to get a true libertarian agenda going and be consistent about it with respect to the Bill of Rights, it might open up a new pathway of thinking, though not a resolution, to the question of reproductive rights and other issues. Now that there are more members at the table who might be thinking of hearth and home than who were considered we the people as part of the political community at the time that the Second Amendment was adopted. So I'm looking forward to some law professors making tenure off of these. I think the inconsistencies point, and I'll close with this, I have a lot more I would like to say, but Dave has made an important observation about the absence of discussion in this case about consequences.
And those of you who are fans of The Wire, HBO program, might think one episode of it may tell us more about handgun control and policy than a 100-page opinion by the court. Actually, though, it's unfair, Dave, because while it's true that in this opinion Justice Scalia subordinates the discussion of consequences to the historical treatment in order to do what he must, which is take this first crack at it. When we get to Boumedienne, you're going to see the opposite. It begins with a discussion of consequences. It starts with, and that's the Guantanamo Bay case, it starts with the dire threat that the upshot, in his opinion, the dissent, that the upshot of that case finding habeas corpus rights for the aliens detained in Guantanamo Bay will cause people to die. He also talks about consequences, though, with cost-benefit analysis in another case we're going to talk about today, which has to do with preemption. And he says the problem with a juror looking at consequences in a snapshot is that they're not calculating across the line the cost of human lives that might be lost by losing a state higher standard of care in a tort case. My objection is not to the way in which he approaches the problem in this case or how Breyer approaches the problem in this case, but the fact that in the same term, with two cases you can lay side by side, or three cases you can lay side by side, the manipulability of the approaches that they all use gives rise to the concern that how it comes out, how the public meaning originalism plays out in this case versus how public meaning originalism plays out in the next case, may be subject much more to the political instincts of the justices than to anything neutral. But I don't consider that news, and I'm not sure that it's any different from it was in the era of Brown. Last thing is, though, he's right. Brown's 8 pages, and Brown is a weirder and weirder outlier in terms of how they approached resolution of the question of equal protection in that case. So I would submit to you, if you like Brown, why do you like it? And is there something to be said for that approach to constitutional adjudication, which spent very little time on history and a lot of time on contemporary reality? Sally?
Thank you, Professor Marcus. Then we'll take some questions.
Just a quick note. One of the great pleasures of, well, a very small pleasure actually, of being alive and a law professor in 30 years after I would have preferred to have been when the court was dominated by people like Earl Warren and William Douglas, is that a lot of the arguments wielded by more conservative law professors of that era can now be wielded by people like me. And so let me summarize an argument in response to Judge Starr that J. Harvey Wilkinson, hardly a liberal, a judge on the Fourth Circuit Court of Appeals, has voiced in response to the Heller case to make the link more explicitly between reproductive freedom and gun ownership. Judge Wilkinson says that Heller will become the Roe for the conservatives, that albatross around the conservative neck, that they're going to have more and more difficulty defending. Now, there's an obvious distinction between Roe and Heller. Heller has a basis in the actual explicit text of the Constitution, whereas Roe, of course, is premised on the right to privacy, that penumbra or emanation from the various zones of privacy covered by the other amendments in the Bill of Rights. But Wilkinson makes the following point, which I find quite compelling. He says, look, going through all this historical stuff, sorting through all the materials, one is led to the conclusion that the historical record is simply inconclusive. So, by Justice Scalia selecting one side of the historical record over the other is simply an arbitrary decision based upon Justice's policy preferences, and one that will become increasingly difficult to defend as a matter of historical methodology. What Judge Wilkinson concludes is that in instances where the historical record is sufficiently spotty as it is here, or where it's as inconclusive as it is here, that why don't we just leave this up to the democratic process? This is the argument wielded by the likes of Judge Bork and so forth in the 70s against Roe, and I think it's an effective one here. The District of Columbia enacted this law in 1976. There's a very well-established democratic process for challenging it through the elected representation in the district, and that's one way to get rid of the law. Let me just comment briefly on the so I think there's this sort of interesting irony in these decisions today that, again, these arguments about democratic legitimacy that were voiced against Roe in cases like that in the early 70s can be turned on their head when it comes to this originalism that we're seeing today in the court. One other word about the consequence of this decision. Yes, I think that the dean and Judge Wake are absolutely correct that this decision will probably not have much in the way of real consequences in terms of invalidating laws like the districts. That being said, San Francisco, the communist city by the bay, and then the much more mainline city of Chicago both have laws that are basically the same as the districts and have already been challenged. So there is litigation going underway that will probably result in those cities' handgun bans being struck down.
Thank you. Do you have any questions from the audience? We've got somebody with a microphone. If you have a question, just raise your hand. Aaron will bring it around. Well, I have a question. No one else does. Judge Starr, in his opinion, Justice Scalia spends part of it identifying limitations on gun ownership that would pass constitutional muster. But he otherwise doesn't seem to do much, as Professor Marcus pointed out, to flesh out a standard for lower courts to apply. Why do you think he did that?
Yeah, and it's going to be a characteristic of why he did it, who knows. But what he does do, which suggests that it's not quite as libertarian as Judge Wilkinson might suggest, is essentially smile on a vast array of gun regulations, gun control, prohibitions, and so forth that do exist. And he seems to suggest a sort of time, place, and manner. Look, guns are dangerous, so obviously society can regulate them. So that doesn't sound very libertarian to me. I think the critical point, and again, this isn't in defense of the opinion, it's not my task to defend it, it's to try to understand it, is that the great divide was, is this an individual right? And it took about 70 pages to come to the conclusion that this is an individual right, not wedded to the existence of the militia. And his having, as he did, smiling on, in sort of a time, place, manner analog, very rough, very crude, to the First Amendment, that the First Amendment guarantees the freedom of speech. But it's not absolute. There are all kinds of regulations, as we all know, with respect to the freedom of speech. So he seems to be saying, let's see what happens here. We're also going to see this non-willingness to tackle, quote, standard of review, which, by the way, was not invented by Chief Justice Marshall. This whole arena of standard of review is very understandable as the court has constitutionalized so many areas. You need some sort of standard to apply. But no lesser light than John Paul Stevens and Craig versus Boren in the 1970s said, what is this standard of review stuff? You have to make, and he has said this in other contexts, hard judgments. And these standards of review, in his view, don't, in fact, accomplish all that they are cracked up to be. Now, he does employ that in the First Amendment arena. But because this is a new arena, I'm not terribly surprised. The basic point is there is no suggestion, quite apart from the wise observation that this may not have that much of a practical impact, there is no suggestion at all in this opinion that there are a whole panoply of current laws that are now in jeopardy.
Yeah, it seems to me also that discussion at the back end of the opinion was foreshadowing a deference to regulation that is short of prohibition. And we'll have to see how it goes, but that's another reason why I doubt that this is going to have a lot of practical effect. It will have some effect. It's almost as though in writing the opinion, Justice Scalia was honoring his sense of obligation and duty to his view of textualism and historicism, and made his point, but not much is going to happen. We'll wait. We'll see.
Do we have any other questions?
Question is for Professor Marcus. Why is it that you believe that the process of the democratic process would be a benefit in voting on other people's rights?
I encourage you to ask questions of the other panelists. Well, your question presumes the existence of the right to begin with, and my when I'm summarizing, I'm not advocating Judge Wilkinson's argument, but to try to represent it once again, his claim is that with a part of the Constitution that's sufficiently ambiguous, sufficiently vague, and one that's not amenable to conclusive historical sort of unpacking, then maybe the court shouldn't short circuit sort of public debate and public dialogue about the right, whether the right exists or not, but rather leave it to the democratic process. And so this is, again, the argument that someone like Justice Scalia might make with respect to abortion, that this is, rather than have the court come in and cut short discussion of whether the right exists or not, this is something that should be worked out legislatively.
Thank you. And we're just about out of time on the Heller case, so I think we'll then move on to Crawford against Marion County. And Professor Marcus, you're up again.
Earl Long was the three-time governor of Louisiana and unfortunately suffered in the shadow of his more famous and colorful brother Huey. But he nonetheless had something very interesting to say about Louisiana politics. He said, "When I die, I want to be buried in Louisiana so I can remain active in politics." At issue in the Crawford case is a law that's allegedly designed to prevent the kind of shenanigans that Governor Long wanted to engage in. In 2005, Indiana enacted a law that requires people to present government-issued photo IDs before voting. This is not a big burden in the ultimate conclusion of the Supreme Court, but it is potentially a burden for those who don't have IDs and may be too indigent to afford the necessary documentation to procure an ID. So the law makes a provision for those people. The people who don't have the government-issued photo ID can cast a provisional ballot, then within 10 days go to a county clerk's office and swear to an affidavit in which they attest that they are indeed the people who showed up on the day to vote, and they are indeed the people who are registered to vote and who did so. The alleged purpose of the law is to prevent voter fraud of the sort that Earl Long would have liked. Dead people voting, people coming in and impersonating dead people who are on the voter rolls and voting, somebody impersonating somebody else and thereby voting more than once. The Indiana Democratic Party, joined by a few others, mounted a facial challenge to the law. In other words, the lawsuit was not an as-applied challenge. The Democratic Party sued immediately after enactment of the law, not waiting until the law had been applied to any particular voter. The argument made by the Indiana Democratic Party is that the law burdens the right to vote in violation of the 14th Amendment. It doesn't do a good job at protecting against fraud and will arbitrarily disenfranchise voters who lack the required identification. Lurking behind the Democratic Party's challenge is the belief that these voter ID laws are designed to disenfranchise poor minority voters or the kind of people who are much more likely to vote Democratic. And just to sort of cite some atmospheric evidence to this effect that these laws have some partisan motivations, between 2005 and 2007, 10 state legislatures have voted on similar laws. 95.3% of Republican state legislators in these 10 states have voted in favor of these laws, and only 2.1% of Democratic state legislatures have done the same. So there is a sense that this is a motivated statute. The question before the court is, does this voter ID law violate the Equal Protection Clause of the 14th Amendment? Now, if anything, as Judge Starr suggests, Crawford is a poster child for poor lawyering. The plaintiff's lawyer at oral argument before the court was unable to answer very intelligently two important questions. One is, has this law ever been applied in a way to actually disenfranchise a voter? Now, the case was a facial challenge and not an as-applied challenge, so maybe it's potentially not a particularly fair question, but the plaintiff's lawyer assuredly should have come prepared with evidence of all sorts of nuns and school teachers and doctors and priests and so forth who had not been able to vote because of this law. Secondly, and more importantly, the plaintiff's lawyer was asked nine nuns were prevented from voting in Indiana a few days after the decision was handed down. More importantly, the plaintiff's lawyer was asked several times at oral argument, how many voters in Indiana actually lack photo ID? And for some mystifying reason, the plaintiff's lawyer answered 43,000. This is 0.9% of Indiana's voting age population of 4.6 million. The real number that is available to anyone who can enter in voting people who lack voter ID or identification in Indiana into Google, the real number is actually 673,926, or almost 15% of Indiana's voting age population. This is from a Federal Highway Administration report. The splintered court upholds Indiana's law against this facial challenge. Now, the biggest issue for the court is what standard of scrutiny to apply to review the voter ID law. In 1966, for example, the court decided a case called Harper, where it struck down a Virginia law that imposed a $1.50 poll tax. And in that case, the court applied a strict scrutiny standard to strike down the law, hinting that the right to vote is a fundamental right. Here, Justice Stevens' plurality opinion declines to use this strict standard. He suggests the strict standard is appropriate when a law invidiously discriminates or when it imposes requirements that are irrelevant to a voter's qualifications. Justice Stevens says that neither of these situations are present with Indiana's voter ID law, even though there is some evidence that the law was enacted for partisan reasons. If the partisan purposes are not the sole reason for the law, then we use a more permissive test. The best that I can make out is that the court uses a balancing test or a sliding scale test to evaluate the law. The state must have a reasonable non-discriminatory interest in the law, and that interest must outweigh burdens that are imposed by the law. So the more severe the burden imposed by the law, the stronger the interest must be. Stevens then goes through Indiana's interest in the law. The most important of the interests offered by Indiana for its law is to deter and detect voter fraud. Now, Stevens acknowledges that the only type of voter fraud that the ID law is likely to protect against is in-person voter impersonation. The problem is that there's no documentation of this kind of fraud going on in Indiana. Indiana, in all of its filings before the court, was unable to identify a single incident in its state's history of in-person voter impersonation fraud. The only instances Stevens refers to in his opinion is voter fraud in New York in 1868 and an example of fraud from a Washington state gubernatorial election in 2004. Now, there are indeed voter fraud problems as identified by keen observers of elections. Absentee ballot fraud is problematic, election officials fraud, and voter registration fraud. By the way, Arizona has a law that addresses the last of this kind. The voter ID law in Indiana does nothing against these types of fraud. Nonetheless, Justice Stevens says that ID law is based upon a sufficient interest in protecting against fraud. Justice Stevens goes through a couple other of the interests of the law, but again, the one that's most important is deterring and detecting voter fraud. Against these neutral, non-discriminatory interests, Justice Stevens weighs the burdens that this law imposes on voters. He says that these burdens are slight. The burden is going to be on a person who doesn't have a government-issued photo ID. Now, there are only 43,000 of these people in Indiana, according to the plaintiff's lawyer. Not a big deal for most voters who don't have this ID. Simply go down to the Bureau of Motor Vehicles and get yourself one. The state of Indiana is willing to provide them for free. But there's a profile of a voter for whom the requirement is a more burdensome one than this. Someone who is indigent, who doesn't have transportation, and may have a difficult time getting to the DMV to get the voter ID. More problematically, there might be someone who may not be able to afford the $10 up to $100 that it might cost to get the required documentation for an ID, a birth certificate or a passport or something along those lines. Again, Justice Stevens says no big deal. If you can't get an ID, just go execute the affidavit. You can show up at the polls and vote with a provisional ballot, then go to the county clerk's office within 10 days and swear to the requisite affidavit. And if you have no transportation, no problem, you can take the bus, have your family drive you, or, as he says in the opinion, ask the League of Women Voters to come and pick you up. The big problem I have with Justice Stevens' opinion is that it's, in my mind, and I'm sure this will raise some objections, I believe it's willingly blind to reality. What seems to be implicit in Stevens' opinion is that the court is not going to strike down a state law based upon a small number of people affected by it. Now, the court disregards evidence to the contrary, that there are actually quite a lot of voters who don't have the ID required for voting, because this evidence is not in the record. In other words, a lawyer's error at identifying the number of Indiana voters affected has a serious impact on the way the court rules, and the court is unwilling to look past the record evidence to the actual evidence of the number of people affected. Also, when Justice Stevens evaluates the burdens, he focuses on a hypothetical individual voter, not on an aggregate. Now, it's certainly true that any particular individual can surmount the admittedly somewhat minor obstacles that this law imposes in the way of voting. But I think that Justice Stevens takes as his hypothetical voter an unusually responsible and civic-minded voter. This is the person who's willing to wait in line to vote, then to get on the bus, take the bus down to the county clerk's office, wait in line there, swear out the affidavit, and only then have his vote or her vote count. Maybe there are indeed such people, but in the aggregate, the average voter who lacks ID, I'm sure, would not be willing to jump through all these hoops. The burden in the aggregate, again, is much more substantial, and many people will be dissuaded from participating. And there's ample social science evidence that the people who will be dissuaded are much more likely to be minorities. Now, you can look at, there are two possible ways of looking at the significance of the decision. The first, just for us locally, A few years ago, we, as the voters of Arizona, passed Proposition 200. This requires people in Arizona, when they register to vote, to show proof of citizenship, and then when they vote, to show government-issued photo ID. This law was upheld against a challenge brought by, I believe, the ACLU, as recently as last month, I believe, by Judge Silver in Judge Wake's court in Phoenix. It's probably going to go on appeal to the Ninth Circuit, but I'm sure that after Crawford, the challenge is likely to fail. So there's the local significance. As for the significance more generally, I think that the opinion addresses an issue of some importance as of late in the court, the difference between an as-applied challenge versus a facial challenge. But I think Sally is going to ask a question about this to the whole panel, so I'll leave that for the time being and sit down.
Thank you very much. Judge Wake.
All right, well, first let's do the math. There were three justices, Justices Scalia, Thomas, and Alito, who wrote for a rather simple, straightforward test that for a non-severe, non-discriminatory voting regulation where there's an important regulatory interest, which there undisputedly was in this case, that the general impact of that is weighed against the important state regulatory interest, and one does not look to the disparate impact on a small number of voters. In this case, people with lesser means who are poor, who have more difficulty getting these forms of ID. Under that, those three justices make this a simple case and would have ended it there. Six justices, in one way or another, opted for what I'll call the sliding scale test, where they the balancing of interest test, but it's really a sliding scale test where you look in a more subjective way about the weight and legitimacy of the state interest and of the burdens that they cause for people. Now, I will suggest to you that sliding scale tests and balancing interest tests they're sometimes necessary, but they rank at the low end of judicial legitimacy, in my view, because they leave the quantification and evaluation of competing social interests in the hands of judges. Those are usually the legitimate tasks of legislators. Sometimes those tests are unavoidable, though. And here we have six justices who preferred that test. The unpredictability of that kind of test is nicely demonstrated in this case, where the six justices of that view split 3-3 as to how this particular case came out under that test. Justice Souter with Justices Ginsburg and Breyer said there's enough evidence here, relying on general statistical evidence. And indeed, there's one place where Justice Souter suggested that if there's any significant disparate impact on the disadvantaged voters, essentially poorer people, that ought to be enough. I wonder whether he really meant that to be an absolute statement. I bring to this discussion a background in my law practice of having done a lot of voting election law litigation as a sidelight to mostly commercial litigation that I made a living at. But I did a lot of voting litigation. And the reality is, having litigated a fair number of voting practices, every voting practice, every voting regulation has disproportionate impact somewhere. There's no such thing as a voting practice, the effects of which are distributed equally on every demographic in society. So the easiest things to identify are such things as lesser financial resources. For example, the polls close in Arizona at 7 o'clock. If the polls were to be closed at 6:30, that would have a disparate impact on people who find it harder to get to the polls and vote. That would be poorer people. I mentioned that as an example as to how everything has disparate impacts on some groups. In this case, the temptation was severe to second-guess the Indiana legislature's quantification of competing values, because there's a look here, although one can't say it, there's a look here that they may have been concerned not primarily with excluding those possible voters claiming a false identification, but rather have been primarily concerned with the collateral discouragement of certain classes of voters, a certain demographic. And that's obviously what moved the dissenters in this case. However, going back to the principal analysis, the other three concurring judges, Justice Stevens, Roberts, and Kennedy, disposed of the case on a somewhat procedural ground, saying, well, we're going to assume that there is some adverse effect here on this group of people, but you just haven't proved a great enough quantum to persuade us that under a balancing of interest test, this procedure should fall. If this were to come back in this case or another case, it is clear that to win this case, somebody's going to have to win over at least 2 votes from the school of thought that says this is an open-ended competing interest balance sliding scale approach. I'm going to suggest that it's going to be very difficult in cases like this for anyone ever to win. Again, and this is based on the judicial mathematics, because Justice Stevens also noted at the very end of his opinion that, by the way, even if you had brought in some real people here and you won, it's not at all clear that you get the remedy of striking down this statute, that this is a valid, would be a valid remedy of striking down a statute on its face. I have a further thought that picks up on what Judge Starr and what David has said. You can't, all I've read is the case here. I haven't read the record, but you can't read this case without grieving as a lawyer for how this case went forward and how it was done. First of all, it was put forward as a facial challenge. Now, for the reason I just noted by Justice Stevens, it may be that even a well-done facial challenge would have had little chance of garnering the votes they needed from those 3 justices to win. But just as a matter of lawyering, one has to look at this and say, the lawyers had the lawsuit without the plaintiffs. They didn't have clients. They didn't have facts. They had a client who had constitutionally sufficient standing, but they didn't bring in facts. They should have done a much higher level of hard work to find real people who you could bring into court and show that this person really would be affected. It would make a difference between voting or not voting. So at a minimum, they could have had a credible as-applied challenge that would have at least given them a remedy for some named plaintiffs. That would be a minimum to seek broader injunctive relief, and as I said, I rather doubt they would have accomplished the broader injunctive relief for the reasons noted at the end of Justice Stevens' opinion. But if you, again, think of this in terms of lawyering and lawyers' service of clients' objectives, who were the clients and what were their objectives? Well, this was a Democratic Party interest in Indiana. They hated this law for the reasons I speculated about. But if they had succeeded in an as-applied challenge, even without an injunction against general application statute, that might have achieved client objectives. That might have led the legislature to go back and revisit this, make some change just from the political embarrassment of having passed a law that has been found to be depriving some identified people of their constitutional rights. So we're here talking to mostly students, so I enjoy offering a little bit of perspective from the lawyer's side as well.
Thank you.
There's no question that disparate impact happens. Anybody who looks at the history of the Equal Protection Clause knows it. Disparate impact happens, and it can be completely foreseeable. Say you have a veteran's preference with respect to employment. You can see it coming down the pike that it's going to have a disparate impact on women. Location of factories that cough up environmental hazards may have a disparate impact depending on zoning laws. Disparate impact happens over and over again, and that's a recurring theme. And most of the time, the principle that is invoked by Justice Scalia in the concurring opinion means if it's neutral and there's no evidence that it was done in order to produce that disparate impact with respect to a suspect class, well, rational basis, game over. It's a whole other thing, in my opinion, when disparate impact happens with respect to the right to vote. It's a baseline that is a priori. If you're going to be a libertarian, if you're going to believe in liberalism, small l, and autonomy, you have to be vigilant with respect to assuring that the political community is drawn as robustly as possible. I see the case as kind of tragic. And when I look at it next to, it's interesting, the four that Sally selected, next to the one that we just did, Heller against, the Heller D.C. case, the political community. It's all predicated on this assumption about what the members of the political community enjoyed as rights early on. And the evolution of it has only slowly come to include the rest of us. In this case, you can see the disparate impact, and it is partisan in terms of the extent to which one party or the other would view them as their base. And that's a problem that should be deemed irrelevant, I think, in some ways to the question. But the larger point of disenfranchisement, I think, ought to have been taken more seriously, and that the foreseeable impact ought to have been taken more seriously, and the factual record that they generated was an embarrassment. Now, the day after, I think it'll be kind of like after City of Mobile, where you say, on the one hand, at-large voting, results in never any African Americans in this community being elected to the council. But later on, soon after, what they do is they come roaring back with a better evidentiary case for the same point. And I think this isn't going away. They stick to the balancing test, so they leave open the opportunity to come in with evidence, and I think the evidentiary burden will be key. But it's going to be, as every post-Washington against Davis case is, establishing that evidentiary burden is going to be tough going. But I see it as true disparate impact happens. And in the political arena, you can't redistrict without having a lot of fallout that may be of great consequence. But I think this is a big one. And I also think the idea that when's the last time you got your driver's license updated? That's a lot of fun, isn't it? These obstacles to getting your voter ID, just imagine inhabit the space of not having done it. When we tried to get the sophisticated faculty to get their CAT cards, you would have thought that this was something that was completely impossible. The email traffic on this was rather astounding. And so, enough.
Judge Starr.
Well, let me make 5 points before moving to, or at least I hope moving into the question and answer session. The first is what seems like a technical lawyer's point, and for those who have not been to law school or not in law school, what is this big deal about facial versus as applied? It is, though, very important to the Roberts Court. And here I want to quote from my colleague at Pepperdine, Professor Doug Kmiec, who was very insightful in the blogosphere. And by the way, I know the students and professors all love the blogosphere. The citizenry should know that some of the richest conversation about the Supreme Court doesn't go into law reviews and isn't found in print newspapers, but it's in the blogosphere. And this is a blogospheric comment from Professor Kmiec. The facial, in other words, under any and all circumstances, this law falls. It is dead. Judge, rule it dead. It should not live at all. Capital punishment for the law. Gone. The court has been reflecting on that in a democratic society, saying, that's, and the court has used this term, strong medicine for the courts to administer. So for some time, the court has been saying, as it has become judicialized, you lawyers out there, be careful, don't just go running off into court, filing some lawsuit because you don't like it. You better be careful, because if we can imagine a constitutional application, you're dead, not the statute. You get the idea. So here's Doug Kmiec's comment. The facial versus as-applied distinction animates the minimalism of the Roberts Court. You may remember that Chief Justice Roberts gave a speech at Georgetown shortly after his confirmation, saying that what doesn't have to be decided in a case should not be decided. But of course, Chief Justice Roberts also said that he would be pursuing a larger number of unanimous outcomes, an aspiration that seemed to run aground in the second term, when the court had one of the highest number of 5 to 4 opinions in decades. So this is now a term before this passed. But the facial as applies distinction that resurfaced in this Indiana voter case, and that has played prominently also in areas of abortion, very interesting, and more recently in the death penalty lethal injection case, reveals that some may have dismissed the Chief Justice Roberts' efforts at achieving unanimity or at least greater consensus prematurely. Is this a fallback position? I leave it to others to divine greater meaning, but what cannot be disputed, and I gather, Sally, you were going to take the conversation there at some point, this is a court that we should, as citizens, be aware of, and certainly as lawyers. You're going to mount a facial challenge, you've got a very high burden ahead of you. The second point I want to make is that, as Professor Marcus's comments and the judge's comments indicated, that the ideological divides are not quite so evident with Justice Stevens writing the key opinion. Yes, it was, as we count the numbers, 3, 3, 2, 1. So, oh no, there's so many opinions. But it's very understandable as to where all the justices were. And Justice Stevens was, I think, in a very moderate position, seemingly guided by, in light of the fact that these baleful consequences that have been very powerfully described were clearly going to happen. You know, there are going to be some unhappy results of the exclusion from the polity, as it were, by virtue of this. So what is a John Paul Stevens, who is typically characterized in the popular mind as one of the, quote, liberals on the court? What's going on here? And Professor Jack Balkin of the Yale Law School put it very neatly. It's a concern about truthiness, fastidious concerns with the appearance of integrity. And I don't say that dismissively. That is, the appearance of integrity is obviously very weighty to Justice Stevens, and then the two justices, the Chief Justice and Justice Kennedy, who joined him. In this connection, a voter ID may have these baleful consequences in at-risk communities. It's burdensome and so forth. Many people do not have a photo ID. But there seemed to be a comparison going on that was perhaps not quite explicit. But is this like the poll tax? And Justice Stevens just says, no, it's not. A poll tax, okay, Harper versus Board of Elections, $1.50. Can you please pony up $1.50 to pay your vote? Okay, that was in the 1960s, so today it would be considerably more than that. But there was an irrelevance to voting that had nothing to do with integrity and reliability. It was almost like a property ownership requirement from yesteryear, albeit a soft version of it. And it applied, by the way, to everyone, universally. It wasn't as if this was being targeted at one particular community, but obviously it was having what the dean called a disparate impact. Poor people are going to be burdened more. But this voter ID simply did not look to Justice Stevens like a poll tax because of the relevance to the integrity and reliability of the process. As I was studying the opinion, I was reminded growing up in a community that tried to have nonpartisan elections. Everybody, I gather, really knew what the party affiliation was, but it was nonpartisan elections. And everyone who was elected was a member of the Good Government League, GGL. Everybody. The mayor, the city council, all GGL members. And I thought, that is really wonderful as a kid. Everybody's in favor of good government. Well, I think that Justice Stevens, 88 years old, growing up in Chicago, and this was in fact noted in the blogosphere in some detail, knows that fraud happens. Maybe it doesn't happen in Indiana, but he saw it. And in fact, he was a lawyer who investigated voter fraud in the Daily Machine, and he is a person of absolute uprightness and integrity, and thus I think that played a very powerful role. But that really leads me to the third point. I'll be very brief on this and the two that remain. The judiciary is really uncomfortable in this area. Judges just don't like this area. Remember Bush v. Gore. Anything you do, and okay, don't remember it. Right? Anything that judges do in this arena is going to be calumnied with motivations called into question. Well, we know why you voted the way you did, etc. And so it's not surprising to me that the majority of the justices would say, let's just don't go there. Perhaps for principal reasons, but perhaps for prudential reasons. But why else would the court just say, okay, if one party is in control of the reapportionment process and they reapportion in such a way and draw district lines so that someone from the opposite party has zero chance in these districts to unseat an incumbent. Zero chance. Welcome to democracy. We're not going to fool with it. We're uncomfortable. Well, how do we articulate a standard? Perhaps we wish it weren't so untidy, but we lament and throw up our hands at the ability to regulate this intrinsically political process. Practice tips, and my point 4. Judge Barker. It was very interesting to me because very frequently in Supreme Court opinions, you don't know who the district judge was. But we know here because Justice Stevens seemed to sort of go out of his way to show what a lousy job the plaintiffs did. We've sort of made that point, haven't we? So why are you beating on the plaintiffs? Because the plaintiffs had a very important case. And listen to this. After discovery, District Judge Barker prepared a comprehensive 70-page opinion explaining her decision to uphold the law. She found that petitioners had, quote, not introduced, now you've heard, oh, disparate impact, and I'm not quarreling with that. But judges have to deal with records. Had not introduced evidence of a single individual Indiana resident who will be unable to vote. If all this disparate impact is in fact true, why wasn't it brought into the record? And thus my final point. Why did the court take this case? Because there was no conflict in the circuits. Rule 10 of the Supreme Court's rules said we take cases that are important. Well, how do you measure importance? One of the great ways are the circuit courts of appeals, the Ninth Circuit versus the Seventh Circuit, are they in conflict? There was no circuit conflict here at all. One of the conundrums, one of the riddles of the case was that even though the judges or the justices don't like being embroiled in this whole political operation where there's going to be a lot of mud thrown at the judges, regardless of what they do, chose to become involved in the first instance. That, to me, was one of the most interesting things about the case. Why? Why grant cert? The Court of Appeals has to hear the case. The Supreme Court of the United States does not. But when it chose to do it, it essentially said, we now wash our hands. Oh, bring your as-applied challenges. But I think the judge is correct. It's going to be a very difficult challenge indeed. I close with this. The Good Government League. One of the things that seemed to weigh in the balance was the fact that President Carter and former Secretary of State and Treasury Baker headed a commission that, while the Indiana law was at the extreme, it was a very extreme law, nonetheless said we need to move in this society in terms of election to voter ID. There needs to be a universal requirement that if you're going to show up at the polls, you need a photo ID. And I don't think President Carter, at least, can be accused of being insensitive to the plight of at-risk communities, but that was one of the, it seemed to me, important dimensions that carried an unusually heavy majority to uphold a law that clearly does have this disparate effect on voting, which is, we would all agree, a fundamental right.
Thank you. Judge Wake, let me ask you about this as-applied challenge. How realistic is that in a voting case? Is your vote going to count if you have to bring an as-applied challenge?
Well, this is a hard case because I try to visualize how you get somebody who is so bad off they can't meet the photo ID requirement but can meet with a lawyer to plan a lawsuit. So now I lost your question. What was your question?
If you have to bring an as-applied challenge, is your vote going to count?
You would, but you'd have to bring it in advance. You would have to prove in advance that you're not going to be able to comply. And so, again, it's very difficult. At a minimum, they should have just gotten better data that, and some real people. So.
Professor Marcus, did you want to comment on the as-applied conundrum?
Just to draw the link quite explicitly, the big issue for as-applied versus facial challenges is in the abortion context, and this is an issue in the Carhart decision of last term. So I just think Judge Starr is absolutely correct to identify as-applied versus facial as one of the great themes of the Roberts Court. In the abortion context, you could probably argue that the as-applied versus facial challenge is particularly difficult, or the as-applied challenge is particularly difficult to conceive of. I think that Judge Wake's description of how one might bring an as-applied challenge here is, I wonder what a judge would think if somebody came and said, I've been planning this lawsuit for several months, but I didn't have time to go down to the DMV and get myself a driver's license.
Okay. Do we have any other questions? Go back to the original questioner.
I would like to know from Dean Massaro, what principle of constitutional law would be offended by making sure that the person who registered is the same person who's voting?
Dave will take that question. None. It's a question of
backing up to Judge Starr's point, where he says that nobody, there's no evidence of anybody who's disenfranchised. There was also the state has the burden of proof in this case. It's up to the state to demonstrate that their measure is justified and proportional. And they concluded in this case, and now I'm quoting the Souter and Ginsburg opinion, that not only does the state have the burden to make a particular factual showing the threats to its interests outweigh the particular impediments it has imposed. Of course, there's a legitimate interest in preventing voter fraud, indeed a compelling one. Of course, there's a legitimate interest in assuring that the person who presents at the polls is indeed the individual who's registered to vote. I don't think anybody disagrees with it. Is this measure necessary to advance that purpose? And there's another way of looking at it, which is that this didn't advance that purpose sufficiently, and it also left completely untouched other problems. So the fit between the measure and the harm that they're attempting to fix, the dissent thought was imperfect. Absentee ballot fraud, which was documented in Indiana, along with other types of corruption, all were things that this measure didn't begin to address. So there's this discontinuity that makes you go, wow, legitimate interest, apple pie, we all agree voter fraud is just as much a worthy interest as assuring that the franchise is fully enabled. But there's an evidentiary disconnect here that makes you a little bit more concerned about what they were doing. And I've just learned not to use Justice Stevens as my platonic guardian.
Actually, maybe those 8 nuns who were turned away would be good plaintiffs.
Yeah.
Of course, it might depend on whether they were turned away because they lacked photo IDs or their IDs all look the same.
Okay, on that note, we're going to take a break now for 10 minutes. There are refreshments outside. Before we start with the next case, which we're debating whether it's pronounced Rigel or Regal, I think we voted in favor of Regal. Judge Wake wanted to revise and extend his remarks.
Yes, I realize I should tell you about my comment about the nuns in Indiana that I spent 6 years studying to be a Catholic priest, so I have standing for a little humor.
How many years does it take, Judge?
More than 6.
It takes 12.
In the Regal case, I think we see what I'll describe as a formalism of the third kind, and to put it quite uncharitably to the court, I'll say that the court in Regal ascribes legal magic to a single word, and the case determines on that magic. Among the 4 opinions, why did we include Regal? As I'll discuss in a minute, the case involves whether FDA approval of a medical device preempts state tort law claims brought by plaintiffs involving these devices for injuries caused by these devices. The FDA grants the type of approval at issue in Regal to no more than 50 devices a year, so this case arguably will not have that wide of an impact. And unlike our cases about Guantanamo, voter ID laws, or the Second Amendment, this case doesn't involve the kind of sexy, great public issue of the day that the other cases are so rooted in. Let me offer 2 reasons why I think this case is included. First, the court will decide a far more important but importantly related case this year, Wyeth v. Levine. At issue in the Wyeth case is whether FDA approval of pharmaceuticals preempts state tort claims brought based upon injuries caused by those pharmaceuticals. In other words, the court might well rule that no tort lawsuits are possible against drug manufacturers for injuries caused by pharmaceuticals. If this is the way the court holds, there'll be a lot of lawyers with cufflinks and tasseled loafers who will be out of jobs. Secondly, Chief Justice Roberts has my legal practice was as a plaintiff's lawyer, so I have standing to make that joke. Secondly, and as Judge Starr has mentioned, Chief Justice Roberts has said he wants more unanimity on the court. And in an interview with Jeffrey Rosen, the Chief said that one way to get agreement is to take more what he's described as business cases. Regal may be a harbinger not only of what the court will do in Wyeth, but more generally for how the court will rule on cases involving business interests in the years to come. On to the case. The Federal Food, Drug, and Cosmetic Act, as originally enacted, did not give the FDA regulatory power over medical devices. In the 1960s and 1970s, there were a number of high-profile injuries from medical devices, the most notorious of this being the Dalkon-Shield disaster, a Dalkon-Shield intrauterine contraceptive device that gave rise, by 1976, to hundreds of lawsuits alleging hundreds of millions of dollars in damages. Some states responded, state of California, for example, responded by enacting their own regulatory measures designed to regulate medical devices. Rather than have this patchwork of state regulations, Congress got in the act in 1976 and passed what is called the Medical Device Amendments, or the MDA, amendments to the Federal Food, Drug, and Cosmetic Act. The MDA requires manufacturers of medical devices seeking to introduce their new product into the market to subject their product to one of 2 types of review. For products that are substantially equivalent to existing medical devices already on the market, the manufacturer simply needs to go through goes through a much less rigorous process by which the FDA confirms that the product is indeed the substantial equivalent of one that's already been approved. For novel products, wholly new medical devices, the manufacturer must subject the product to the pre-market approval process, what the court calls a rigorous process, in which the FDA minutely scrutinizes the product, balances the likely harm the product might cause against the likely benefits the product promises. And if it finds this equation favors approval, it grants approval and the product goes on the marketplace. Regal concerns the products subject to pre-market approval. This is a small minority of new medical devices. So in 2005, for example, over 3,000 medical devices were approved pursuant to the substantial equivalence standard, whereas only 32 products were approved pursuant to the pre-market approval standard. Products subjected to pre-market approval, again, are subjected to this scrutiny that's quite rigorous. The FDA imposes very specific requirements relating to the product itself, what the manufacturer must do to make the product sufficiently safe, what the manufacturer must put on the warning label, and so forth. So very precise regulations of the product before the product is approved. And importantly, I think, if the product is changed after it's on the marketplace, those changes must be approved by the FDA. Quite important for our purposes is the MDA's Preemption Clause. The MDA provides, no state may establish or continue in effect with respect to a device any requirement which is different from or addition to any requirement applicable under this chapter to the device and which relates to the safety or effectiveness of the device. So the MDA preemption clause applies to any requirement which is different from or in addition to any FDA requirement for the device that relates to safety or effectiveness. This case involves something called a balloon catheter. Charles Regal underwent coronary angioplasty in 1996 after suffering from a heart attack. The surgeon used the balloon catheter manufactured by Medtronic to dilate his artery. Now, unfortunately for Mr. Regal, the catheter that the surgeon used was contraindicated for his condition. Also, the surgeon inflated the catheter to a pressure that the catheter was not designed to sustain. So the catheter exploded, and Mr. Regal went into a serious, I think he went to cardiac arrest, ultimately was saved, but he has passed away since then. He and his wife brought suit in New York, bringing a standard raft of state common law tort claims, product liability claims, negligent manufacturer claims, breach of implied warranty, and the like against the manufacturer. The question before the court is, does the MDA's preemption clause preempt Regal's common law tort claims? Justice Scalia, writing for the majority, and this is, I think it's I'm blanking, but I believe it's an 8-1 majority with Justice Ginsburg in dissent, says yes, the MDA's preemption clause preempts state tort claims. Now, the main question in this case is, are state common law tort duties requirements within the meaning of the MDA's preemption clause? Now, there's no doubt that tort duties pertain to safety and effectiveness. But are they requirements? Are state tort duties requirements within the meaning of the preemption clause? This, for me, is a hard question. Certainly, tort duties are not requirements of the sort the MDA was clearly designed to preempt. The patchwork of explicit state regulations that were threatening to impose this patchwork set of regulations on a national marketplace. Justice Stevens, in a plurality opinion from a case a dozen years ago involving the MDA, said that the word requirement is not a particularly apt way for referring to state common law tort duties. Nonetheless, the court in Regal says that the term requirement does, in fact, include common law tort obligations. Now, I'm going to be very uncharitable to the court and suggest that the real reasoning for this is a very formalistic one. The court had said, as Justice Scalia says, the court had suggested that the term requirement means common law tort duties in 3 cases in the past, and, quote, Congress is entitled to know what meaning this court will assign to terms regularly used in its enactments. Now, this is all perfectly good, assuming that Congress phrases statutes based on how it thinks the court is going to interpret them. A very contestable assertion, by the way, in the preemption context, where Congress has proven quite unwilling or ignorant of the way the court rules in preemption cases. That's been empirically demonstrated. But more importantly, each of the cases Justice Scalia invokes to support his argument were decided in the 1990s or later. The MDA was enacted in 1976. So, to be uncharitable, I would suggest that Justice Scalia's argument either stands on the notion that Congress can predict the future, or on the notion that the term requirement is a magic word that necessarily includes, without consideration of context, policy, or anything else, common law tort duties. Now, again, I'm being unfair to the justice. There's a little more policy analysis in his opinion than I'm suggesting. There's the argument that common law tort obligations are like state regulatory statutes, clearly covered by the preemption clause, because tort is a powerful way of governing conduct and controlling policy. Tort performs a regulatory function just the way that positive enactments do. But tort law, of course, also performs compensatory function. And in this case, compensatory function of tort is quite different from its regulatory function. Also, Justice Scalia says, having tort lawsuits will disrupt the delicate federal regulatory balance. The FDA carefully balances costs against benefits when deciding whether to grant pre-market approval. And we don't want a jury evaluating a common law tort claim to come in, only see the costs of the product and seeing the injured plaintiff and ruling accordingly, not seeing the benefits of the product, and thereby disrupting the delicate federal regulatory balance. But as Justice Ginsburg points out in her dissent, the FDA also scrutinizes drugs for pre-market approval just as strictly as it does medical devices. In other words, there's a regulatory interest that's just as delicate and precise in the pharmaceutical context. But the court, takes pains to note, and I think she does so with an eye towards the Wyeth case, she says, the court has never held that the Federal Food, Drug, and Cosmetic Act preempts tort claims against drug companies, and yet for decade after decade, we've been able to have effective regulation, or some might not say effective, but we've had regulation of pharmaceuticals and tort claims side by side. What we don't get in Regal, in my mind, is any consideration of the justification for federal supremacy in the regulatory field, and no argument about respective spheres of competence. Tort versus regulation, state versus federal. There's no acknowledgement, for example, that the FDA, by its own admission, has only half the personnel it needs to effectively fulfill its mission, or the FDA, in a recent report that itself authored, said the following: the scientific demands on the agency far exceed its capacity to respond. This imbalance is imposing a significant risk to the integrity of the regulatory system and hence the safety of the public. The true significance of Regal is the fact that it's most likely a warm-up act for the Wyeth case, the much more significant case addressing the question of whether the FDCA preempts claims against drug companies for injuries caused by pharmaceutical ingestion. The Wyeth case will be an implied preemption case. There's no explicit preemption clause on the table. So the analysis in Regal is not explicitly on point. But that being said, I think Regal helps us see the tea leaves of where the court is going. Justice Scalia, based upon his policy analysis in Regal, will almost certainly vote for preemption. That's my prediction. Justice Breyer, based upon comments he made at oral argument, will almost certainly vote for preemption. And if the Chief really means what he says about unanimity in business cases, I think he will too. So I think this is where the court is going, but I'll let the panel comment on that.
Thank you. Judge Starr?
Well, let me talk about.
As they say on the airlines, thank you for your patience. They should say, we know you're impatient, thank you for your obedience. They would also be wise to say, and we're impatient too. We wish the jetway would actually come so we can get off this aircraft. But in any event, I digress. I want to talk about the numbers just for a moment, because we're here to learn about the court. And not just the court's term, but we're here again in the shadow of Chief Justice Rehnquist. We're here on Constitution Day. Why are we talking about a tort case to begin with? Professor Marcus rightly called our attention to the supremacy of federal law. And that's one of the established doctrines. We may not particularly like it at times that federal law supplants and is supreme over state law, but that is the nature of our federal republic. But in the numbers, the Heller case was 5-4. The Crawford case, and Judge Wake provided us with a breakdown of the numbers, but bottom line, 6-3. That's we've now moved, and Professor Marcus is exactly right, 8-1. So what's going on here? The response to this particular decision was consumer advocates were outraged. And Senator Kennedy, agreeing with consumer advocates, issued a very strong statement condemning this decision and saying that Congress will move forward to change the law. Let the record show it hasn't happened. But Congress is busy. But what's going on? Why are these, is Justice Stevens anti-consumer? Does he not care about injured plaintiffs, about fairness, justice? Aristotle's definition of justice, to each person his or her due. Someone's been injured. Let them go to the jury and explain the case. Nope, preempted. Federal law has preempted you. What is going on? Point one, elections have consequences. You see, the Federal Drug Administration did not take the position in the 1990s that there was preemption in these particular, admittedly limited circumstances. 1% of medical devices go through this elaborate approval process that has been held now to preempt state tort law. But that changed. That was the position in the 1990s. That changed in this decade. And it changed very transparently. It does, said the FDA, and the courts have been agreeing. That brings me to a broader point that far transcends this case and tells us, I think, a bit about the court under Chief Justice Roberts. This is a very Hamiltonian court. What do I mean by that? Remember Alexander Hamilton and the great nationalist and doing all manner of federal programs, as opposed to in that first cabinet, Mr. Jefferson, hoping that the republic would remain agrarian and yield person republic, and that the federal government would truly be limited, who was in anguish over the Louisiana Purchase, feeling that he had violated the Constitution because he had no power to authorize what he did. But as a prominent historian at the University of Virginia put it, his constitutional theory was unconstitutional, but you have to remember Mr. Jefferson was a good real estate man. And so Louisiana was purchased even though he did not have the power to do it. And why did he think he didn't have the power to do it? Because he had this very anti-federalist vision of a limited federal government. This court is extremely Hamiltonian when it comes to federal laws bumping into and against state regulatory requirements. And it can be state law, or it can be, as here, and Professor Marcus quarrels with that, a state jury articulating a view that would be inconsistent with the FDA's view. That brings me to a broad point that is less political and has more to do with the judicial culture. This is a court that, because there has been the judicialization of the Supreme Court, none of the justices ever sat in a legislative body, heard testimony about the difficulties of life and the needs for ameliorative laws and how the tort system could be improved, etc. This is a court that embraces robustly the culture of expertise and has very little use for populism. This is a court that Mr. Jefferson would not like and Mr. Hamilton would like a lot. And you might say, well, that sounds like a political agenda. Well, one of the most articulate voices on the court with respect to the importance of expertise is Justice Breyer. Fourth, even more broadly, the court is very skeptical of civil litigation generally. It doesn't trust the civil litigation system, doesn't like it, and frequently will interpret laws so as to cabin and curtail civil litigation. Those who have been steeped in the world of arbitration and the court's various opinions interpreting the Federal Arbitration Act will know that it has embraced a very, very robust, wide theory of arbitration contracts. It's a matter of contract. Displaces, even when the parties want to contract around or limit the arbitral duty, this court just does not like civil litigation. That, again, is pan-ideological. It has nothing to do with what party the justice came from. It has nothing to do with who appointed the justice. Look at class action law. Look at Ruth Ginsburg, who is a proceduralist through and through. If you're going to have a class action under Rule 23, you're going to turn square corners. There are going to be no loosey-goosey glass actions allowed on her watch. And that's Ruth Bader Ginsburg. And she carries a heavy majority of the court with her when it comes to class actions. Those have been typically 7-2. My final point, preemption is a very important subject that I'm glad to see it lifted up in this gathering. If Sally, Bill Souter, General Souter were here providing advice to lawyers, watching as he does literally as the clerk of the court, and a very fine lawyer, a distinguished lawyer in his own right, prior to becoming the clerk of the court and a great public servant. He would say, law students need to know about preemption. That's a very important practical subject, and the Supreme Court of the United States handles 4 or 5 preemption cases every single year. Learn preemption. He would also say, and this closes my overlong comments and brings me back to Alexander Hamilton, learn about the Dormant Commerce Clause, the great judicial power of keeping the commercial lines free of discriminatory state legislation, protectionist typically state legislation to protect the local state, and even unduly burdensome regulation by the state. Because ours is a great national economic union, and even if Congress has not exercised its power under the Commerce Clause, then it is a great and mighty power indeed, CEG, the 1964 Civil Rights Act, justified constitutionally notwithstanding its deep reach into the economy on the basis of the Commerce Clause. But even when Congress has not acted, there's a very important role for the judiciary, and law students need to know that, called the dormant. I love that term, or it's sometimes called the negative Commerce Clause. That is to say, Congress has not acted, but even in the absence of any congressional action, it is still the job of the federal judiciary, the judiciary generally, but especially the federal judiciary, to strike down those state laws, because we've had a lot of paeans to democracy here today. But remember Madison's Federalist 10. Madison's Federalist 10 warns you that boss hog may control the arm of government, including law enforcement. Does anyone know what I'm talking about? Boss hog. Remember the crazy, there are two people here who know this reference, a crazy television program where this mayor of this little town controlled Sheriff Roscoe B. Calhoun. You get the idea. That's Madison's Federalist 10. And so it is that special interests, you might say special interests, don't they control Congress? You can quarrel and we'll argue about that. But what you know is, with all due respect to all the state legislators here, they control state legislators. They control them, and I mean in a non-corrupt way. But if the special interest, this interest wants that, they're going to get that, and without the most transparent kind of process. This is what is going on. This court gets it. They are very Hamiltonian, and a lot of people don't like it because Thomas Jefferson, leaving slavery issues aside, Thomas Jefferson appeals to a lot of people's instincts. There is, after all, a Jefferson Memorial, and Alexander Hamilton only has a book written about it.
Well, I have to say that the chief pointed out that there is a statue to Alexander Hamilton in front of the Treasury Building. So,
Absolutely. See, the chief is always, even from the grave, is corrected. And so, thank you, the voice of the Chief Justice. I once again stand corrected.
Judge Wake, we're running a little bit close to our time limit here, but if you'd
How
like
much
to...
time do I have? I'll fit it in.
You have as much as you'd like. You are
No,
the judge.
no.
If you take 3 or 4 minutes...
All
and
right,
Dean
all
will
right.
take 3 or 4
The
minutes.
most important thing is no loosey-goosey class actions. Can I use that in a future opinion? So, but,
You are in the Ninth Circuit.
or district court.
Further affiant saith not.
Well, this case, Regal versus Medtronic, is a worthy selection for our discussion because it is a nice example of how courts must deal with tension between statutory language and likely legislative purpose. This is a much closer case than the 8-to-1 array of justices would lead you to believe. And I say this is a close case, not merely because I own stock in Medtronic, which I hereby disclose, but for the reason that Justice Stevens hits in his concurrence, where he says that this preemption provision in the Medical Devices Act of 1976, quote, is an example of a statute whose text and general objective cover territory not actually envisioned by its authors. So, what do? The majority of 8, including a somewhat agnostic Justice Stevens, takes Congress at the plain meaning of its expansive language and finds state tort law preempted. But there's nothing but the language of the statute itself to suggest that state tort law comes within the sweep of it. And one would expect a move of that magnitude to leave some fingerprints somewhere that is not to be found anywhere in the legislative history. So Justice Scalia says, the operation of a law enacted by Congress need not be seconded by a committee report on pain of judicial nullification. Well, Justice Ginsburg comes at it in a different way, exploring the issue in the legal environment of the common law claims at the time of the enactment, and the statutory language of preemption dealing with requirements was general, but words only have meaning in a context. And the context there, Justice Ginsburg says, was one of universal acceptance of, she didn't say this, but it's how I say it, the cost-spreading function of personal injury tort law. She accuses Justice Scalia of taking abstract words out of their actual context. And this reminded me of a passage that I'm fond of from the late Professor Paul Bator concerning interpreting statutes that are necessarily brief. And he said he was writing a different statute. But these statutes were themselves passed against the backdrop of a large body of standing law on matters of substance, remedy, and procedure. As is true of all legislation, it is a matter of interpretation how to fit the new enactment into this pre-existing texture. No statute recreates the entire legal universe. Therefore, this comes to mind for me because would one have expected Congress to use more precise words to oust state tort law? Perhaps so. And there is a particular danger in a literalism without the comfort of knowing that something dramatic was intended. And that is that even though there may be good substantive policy for preemption here, when the courts find preemption by inference, they are absolving Congress from its political accountability. I mean, there isn't a lot left to our federalism because Congress can preempt virtually everything of our law now. But what there is political accountability. Congress has to stand up and say, we've decided to oust state law, state power in this area, and if you don't like it, come to the next election. When the courts discover it by inference without clarity, that political accountability is defeated, and the federalism is turned on its head. State law is the default position of our Constitution, and the Constitution is designed to make federal legislation not easy to get through. And in the absence of a congressional bicameral majority, state law is the default position. And if Congress thinks it's a good idea, it ought to say it. That is the case to be made against the 8 and in favor of the 1.
Thank you, Judge Wake. Dean Massaro, you can have the last word.
I'd rather it came from Barbara Atwood, who knows a lot more about this than I do. The presumption against preemption just gets ushered out. She's the only one who really mentions it, and I thought that was striking. And I don't know what to make of it, and I'd have to look at more cases over time to see whether this is an outlier, even though it was 8-1. But I said earlier, lawyers and judges, if we're going to be approaching this under constitutional interpretation as historians, we better become better historians. Good luck with that. It's interesting, in this case, this is not a constitutional case, it's a tort case. This opinion doesn't start with consequences in the way that the next one does, but it does suggest, Scalia does suggest a way that we might think about consequences. And what it is a law and economics frame. That's the language of the opinion that emerges to the extent that he's isolating an approach, and a law and economics frame takes a different approach to the tension between states and the federal government, seeing the states as sort of competitors in the regulatory scheme versus a compensatory method. Where does that come from, and how are we going to manage it? It's certainly not, as Judge Starr says, very democratic at all. It suggests, in the opinion, juries just aren't very well equipped to conduct this type of analysis. I don't think judges or lawyers are that great at it either. And so in this case, they defer, but the question is, to whom are they deferring? I think Judge Wake and Judge Starr are right that there's a federalism issue here, and what's happening in essence is they're deferring to the federal government. Okay. Is this cause for consternation or not? Is deferring to the legislative branch and things, if we're going to adopt a law and economics frame, a better approach or not? I would say this, that 9 years ago, I guess, a long time ago when I was in law school and was on the law review, one of the students was writing a note, and it was the role of the juries in complex litigation. Should we abolish the use of the jury? So this is not a new point. The jurors might not be that great at these kinds of analyses, but I think it has become more insistent, partly for some of the reasons mentioned by Judge Starr, but there's a bigger macro point that I would want to make, and that is if you abandon formalism in favor of a recognition that the problem is fundamentally a policy question, you're going to, and if you're going to give some part of it to the judiciary, you're going to have to give them some sort of framework for thinking about it. And I think Justice Breyer in this way is less the voice of an anti-populist than the voice of latter-day or modern-day remnant of or culmination of legal realism. You forego the formalism, and then you look at how cases are really decided, and that's going to be on the basis of data. And I think he's particularly likely to engage in that kind of thinking. He's a former administrative law professor, and he's written extensively on administrative law. He knows a heck of a lot about it. And so he's suggesting that we ought to really look at these things and evaluate them in a lot of cases. I think the pattern the judges identified is spot on. But I think that embedded in this is this question of, do we use cost-benefit analysis and what the implications are for the judiciary, what the implications are for lawyer training, what the implications are for whether or not the lawyers know or the judges know what they're doing, versus deferring to agencies that might be better at it. Two quick points. Scalia spoke out against the media coverage of this case at a meeting convened by the Food and Drug Law Institute. What did he say? The coverage failed to focus on the text of the laws, and it made it seem the court was reaching policy judgments instead of basing its decisions on the text of the laws. One rejoinder I have to that, when you consistently lambaste your fellow justices for and it comes from both sides, for judicial activism, don't be surprised if the press picks up on that theme and doesn't drill down into the narrow aspects of the case. And I think that was, you're going to see in the next one by way of transition, where he accuses his colleagues of terminal, simply incorrect analysis competing with his as grotesque. Terminal silliness is a phrase that he's used. I think that this invites the kind of media coverage that we see, not very sophisticated coverage of what the court actually did in the case. The more important case is the one pending next term. Why? Because it's even more ambiguous what Congress meant with respect to the preemption question. And I'm hoping Barbara will have something to say about that presumption against preemption.
Thank you. I think we're going to have to move on to stay on schedule.
Sorry, Barbara.
Unless, Barbara, do you have something to say? All right.
Our last case of the day is the case Boumedienne V Bush. I will ask the dean for an extra year to make tenure for having to summarize this case. I spent a tremendous amount of time on this and don't think that I adequately can do so in 10 minutes, but I will do my best. Boumedienne is the only case of the four that I think is actually rightly decided on grounds that aren't rigid and formalistic. Here, I believe the court actually does face up to the quite hard question posed by it squarely, acknowledges policies at issue, and decides accordingly. This being said, I still don't like it. So there are two questions at issue in Boumedienne. First, by the way, the pronunciation is the Chief Justice's, not mine. I'm not trying to impress you with my high school French. Two questions in Boumedienne. First, do aliens detained at Guantanamo as so-called enemy combatants in the War on Terror have a constitutional right to seek a writ of habeas corpus in the American courts? If the answer to that first question is yes, did Congress lawfully suspend the writ when it passed a statute in 2006 that cut off access of these detainees to habeas? You may well think, wait, hasn't the court decided this question before? And in fact, the court has addressed the rights of alleged enemy combatants held in Guantanamo several times. And to make sense of what the court decided in Boumedienne, I think it's helpful to go through the history leading up to the case. On November 13th, 2001, the President issued an order establishing military commissions to try persons as so-called enemy combatants. The idea was to preclude these individuals from getting access to federal courts. To this end, the administration decided to hold these individuals at Guantanamo Bay, Cuba. And Guantanamo has very unusual status. It's formally within the sovereign territory of Cuba. But a 1903 treaty with Cuba gives the United States a perpetual lease over the territory. The Supreme Court in the 1990s held that American laws do not have extraterritorial effect in Guantanamo, and so the idea went that the detention facility would be outside the constitutional reach of the United States, and enemy combatants there would not have access to constitutional rights. The first detainees were held in Guantanamo starting in the winter of 2001, and by early 2002, the first lawsuits were filed on their behalf. The court addressed detention issues for the first time in two important cases in 2004. The first of these cases, Hamdi V Rumsfeld, the court held that the president does in fact have the power to detain people as enemy combatants. So once somebody is determined to be an enemy combatant, the president may detain him lawfully. But the court also concluded that the alleged enemy combatant in that case, who happened to be an American citizen, had a Fifth Amendment due process right to notice of the factual basis of his classification and an opportunity to challenge that classification before a neutral decision maker. In the second of these 2004 cases, a case called Rasul, the court held that the federal habeas statute, this is distinct from the Constitution, but the habeas statute that gives federal courts jurisdiction over habeas petitions, the court held that this federal habeas statute applies to non-citizens held at Guantanamo. So the statute has extraterritorial effect. There were two immediate responses. First, the Department of Defense, in response to Hamdi, enacted a series of regulations setting up something called Combatant Status Review Tribunals. And these tribunals were enacted to provide the sort of process to people accused of being enemy combatants that the Hamdi court required. I'll return to these later. Congress also passed the Detainee Treatment Act, amending the federal habeas statute to trying to strip federal courts of jurisdiction to hear habeas petitions from Guantanamo detainees. And there's one more chapter leading up to Boumedienne. In 2006, the court decided a case called Hamdan. In the Hamdan case, the court held, among other things, that the Detainee Treatment Act did not apply to detainees who had already filed their petitions. So it did not have retroactive effect to apply to people who had already had their petitions on file. Congress responded by passing the Military Commissions Act. This amended the federal habeas statute to quite explicitly strip the federal courts of their habeas jurisdiction over all petitions, including those already on file. So after 6 years of litigation, the court finally has the big enchilada before it. Does the Constitution apply extraterritorially to provide alien detainees at Guantanamo with the right to seek habeas corpus? This is the real question that I think all these other cases are simply leading up to. The first half of Justice Kennedy's opinion is, I believe, a brilliant example of what I'll call a functionalist or realist approach to constitutional interpretation. This half deals with the question of whether the Constitution applies extraterritorially to guarantee a right to seek habeas corpus. Now, one way to answer this is to ask, did the framers intend the Constitution to so apply? And Justice Scalia in his dissent goes through this historical argument and concludes that English courts, as of the time of the Constitution, had no such habeas jurisdiction over aliens detained abroad, and therefore our Constitution does not provide that jurisdiction either. Justice Kennedy also engages in a lengthy historical discussion, but he finds the historical materials much more inconclusive. There's all sorts of discussion about the rights of people held in Scotland and held in the Channel Islands and in Hanover, Germany. And Justice Scalia says, in my mind, quite fortunately, that this historical record is simply too inconclusive to say whether in 1787 the founders intended the habeas provision in the Constitution to apply extraterritorially to aliens detained abroad. So how does Kennedy answer this question? After all, it is a quite tough one. If the court were to go with the government's argument here, the argument argued that the answer is the habeas provision only applies within the de jure sovereignty of the United States, or that is, within the formal legal sovereignty of the United States. Guantanamo is outside this de jure sovereignty, and therefore it doesn't apply. If the court had followed that argument, then there'd be a legal black hole in Guantanamo. Cuban courts don't have jurisdiction over Guantanamo Bay. But the Guantanamo Bay would not be subject to American law either. So the Congress and the legislature, Congress and the president would have combined to create a legal black hole. On the other hand, if habeas applies to anyone held anywhere in American custody, that is within the de facto control of Americans, then we would be seeing habeas petitions from detainees in Iraq and Afghanistan, on battlefields across the world. The potential for habeas to disrupt sensitive military operations and the like, or foreign affairs, would be quite dramatic. Instead of some bright-line rule, the court adopted, or Kennedy adopted, what he called a functional approach, a three-part standard for assessing when a detainee may seek habeas relief. This standard takes into account, for example, the nature of the sites where the apprehension and the detention take place, and practical obstacles inherent in resolving the petitioner's entitlement to the writ. So let me give you the two examples that Kennedy used to contrast with the Guantanamo incident. Let's take a German held in military prison in Germany after World War II. After World War II, the Allied forces occupied 57,000 square miles of territory that included 18 million people. The United States was part of a four-country occupying force. The occupation was supposed to be short-term. German institutions were still partly functioning. There were potentially thousands of prisoners who might have access to American courts if habeas applied abroad. There were persistent security threats at the time. The Soviet army, of course, was about to sweep across the rest of Europe. So habeas might divert our attention and compromise military mission. In comparison, Justice Kennedy suggests Guantanamo is a place where allowing habeas might not be such a bad thing. Small territory, 45 square miles. The inhabitants are only U.S. military and the detainees. The United States has exclusive control, if not sovereignty, so there's no potential friction with a host government, the Cuban government, if the federal courts start issuing habeas decisions. There are no other institutions to provide relief to detainees. And so, Justice Kennedy concludes, in this instance, there should be habeas. The right to seek habeas corpus should extend extraterritorially. This functional approach, I would assert, is flexible enough to protect against the legal black hole established at Guantanamo, while meaning that the writ does not necessarily extend to active places of military conflict like Iraq or Afghanistan. Where Kennedy's opinion goes astray in my mind is the second half. Given that aliens at Guantanamo have this right to seek habeas corpus, did Congress lawfully strip this right when it enacted the Detainee Treatment Act, which stripped the federal courts of jurisdiction over habeas petitions filed by Guantanamo detainees? The suspension clause provides that Congress can strip the right to seek habeas corpus in times of invasion or rebellion when the public safety so requires it. And there's no question that these prerequisites are not met in this instance. So the question is, did Congress provide an adequate substitute for the normal habeas process with the combatant status review tribunals I referred to earlier? Now, these CSRTs are modeled on what the court said due process requires in the Hamdi opinion. Justice Kennedy says, well, look, even if the CSRTs are adequate to meet for the purposes of due process, the point of habeas is to catch errors in the course of normal adjudication. The CSRTs give rise to considerable risk of error. Detainees don't have lawyers, they have limited means to challenge the government's evidence, and hearsay is admissible in the CSRT process. For habeas review, the court needs some way of assessing the sufficiency of the government's evidence against the detainee and an authority to admit and consider exculpatory evidence. The problem is the statute that applies here only authorizes the D.C. Circuit in sitting in review of the CSRT findings to assess the legality of the process itself, but no power to consider exculpatory evidence or revisit the factual findings of the CSRT. Okay, well, this all sounds fine and a compelling reason for why the CSRTs do not amount to an adequate habeas substitute. But I think the Chief Justice has a point in his dissent where he says that this is an elaborate bait and switch. The Department of Defense modeled the CSRTs on what the court held due process requires in Hamdi, and only after it does this, the Department of Defense comes back before the court and have the court lecture it on adequate process under the guise of habeas and not due process. I think there's a point to be made about the bait and switch that Chief Justice Roberts articulates. Also, in my mind, the real flaw is that Kennedy does not outline precisely what processes must be in place for an adequate habeas substitute. He does not say, for example, whether this habeas substitute must include the right to counsel, access to government's evidence, or the like. This is for the lower courts to sort out. But this is a problem. There has been litigation over the process due to these detainees since 2002. This is the fourth Supreme Court decision on this particular subject. I wish the court would simply just end this litigation, prescribe what is necessary, and let the administration go about its business, giving these people their day in court. But the court is unwilling to go this far, and I think that this is a flaw.
Thank you. Dean Massaro.
Okay, I see this as having a lot of potential consequences, and in the interest of time, I'll go rapidly through them. First of all, there's no question this is another rebuke to the Bush administration on Guantanamo Bay practices. Everybody understands this, and it undermines, at least somewhat in this context, the characterization of the current court as excessively deferential to federal authority, because here you have both Congress having spoken along with the executive branch. Second thing is it's an indication, this is subtler, that Justice Kennedy is pursuing further his liberty strand. I think this is emerging, and you need to think about him because it is the Kennedy court. And in this, he identifies habeas corpus, and the separation of powers theory itself is fundamentally about individual liberty. I think we're starting to get, some of a sense of, his construction of the Constitution. He's a little harder to read than Justice Breyer or Justice Scalia on that point. Third, it reinforces the need for due process limits on military commissions, no question, and the need for Congress to address the shortcomings perceived with respect to these or prepare the federal judiciary for terrorism trials. Fourth, the optics of this case surely matter. It sends an internationally significant signal of judicial oversight and the importance of treating aliens under our jurisdiction with proper procedures. And therefore, it has done another thing, the optics of it also. This case has definitely become a political dividing line, with the candidates for the presidential election seizing on this one. In the case of our senator, first not because he's been opposed to some of the practices at Guantanamo, not speaking to it, and then in later statements being emphatically against the ruling in the case. And I think it's just the politics forcing probably both candidates to be more emphatic than maybe they really are. Sixth, the chief is exactly right. There's a lot of procedure already in place. And what this ruling does as a practical matter is, I think he's right, he adds another layer. So it's not necessarily going to be accelerating these cases. He also says, and I think it's important to stress this in his characterization, that what's happened here is that the procedure that struck down here provided more opportunity and more process than that afforded prisoners of war or any other alleged combatants in history. And again, the way in which people read these things, unless they're quite sophisticated, it's a little difficult, I think, for people to really parse that unless they have some sense of these older cases that the court is dealing with here. It's also another illustration of the long legs of Korematsu. In Korematsu is a case in which there is the judicial self-awareness of the importance of deference to the military national security point, and it's an internment case. And yet, the Constitution is not a suicide pact on the one hand. We all accept this. On the other hand, the retrospective about Korematsu is that they gave insufficient attention to civil liberties in that case. And we all respect that as well. Right after 9/11, when we were rapidly developing legislation and people having to speak under enormous pressure, a direct reference was given to Korematsu and the importance of not making that mistake again. So we have two very well-accepted principles in tension here. And the court has always had a difficulty balancing national security where it's least capable, in many people's eyes, to juggle or evaluate the facts, weighed against individual liberties where, if not the court, who? And so that's what's going, compare the Pentagon Papers or other cases that test the balance. And then, of course, we've got the growing apprehension about declaring a war on terrorism and hearkening back to cases coming from World War II or elsewhere in a context in which we have a war that has no end. And so this, and the length of the declared war and the length of internment, these are serious questions that may force us to come up with new models. Bromides really aren't all that helpful here. So those are some of the things I think the case does. What it doesn't do, it does not force the administration to forego military commissions in favor of Article III courts. 2, it does not answer the issues that will be raised on appeal in Hamdan's case on both sides. The legitimacy of the commission that heard his case, and whether commissions are going to be replaced by federal courts, and if so, subject to what restrictions on the trials in the interest of national security, or perhaps the construction, as some have argued, that we create a national security tribunal. And it doesn't answer how suspension of the writ of habeas corpus would be handled in a different factual context at all. This might be a bus ticket for one ride only, because it's really directed to, Kennedy is directing his analysis here to the fairly unique facts of Guantanamo Bay. And finally, it doesn't answer the bigger question. To what extent should Congress acquiesce in matters of national security in the current and evolving political environment? I think it will cause Congress to be more wary of allowing any political appointee to serve as the convening authority, which is something that's built into this model. And it may cause them to, Colonel Morris Davis, who's regarded as an advocate for the Office of Military Commissions, resigned from his position as chief prosecutor of the Office of Military Commissions, the OMC. And you had, that voice, according to many accounts, having to do with the court's decision to take the case. Concerns about unlawful command influence persist. And that is, and those concerns are raised. This is not a courts-martial situation where the interest of having the military adjudicate this and giving deference to the military are consistent with the responsibilities of the military in those contexts, which is they have the power of the military commanders in those cases in courts-martial, But here they have those powers without the attendant traditional justification for that power, which is command responsibility. And so I think that these are some of the things in a more sophisticated subsequent analysis that will have to be answered.
Thank you. Judge Starr, I'm hoping in your comments you might address the rather curious fact that Senator Arlen Specter voted in favor of the Detainee Treatment Act and then in this case filed an amicus brief arguing that what the Congress had done was unconstitutional.
Hamlet springs to mind. We began today's reflections with Heller, and we now conclude with the Guantanamo case, Boumedienne. And one practical lesson is that Justice Kennedy is terribly important. You'll note that in each time, all of the cases we've discussed, he's been in the majority. That was not always the case this last term, in contrast to the term before. But in these 5-4 decisions, and it is no accident, I'm sure, that he was assigned the opinion by the Justice Senior in the majority, Justice Stevens. And so as Justice Kennedy goes, so goes the court. In the tradition of that great Arizonan Sandra Day O'Connor, it was for several years or terms the O'Connor court. In many respects, it is the Kennedy court now. The second point, the holding was unprecedented, and we should recognize that, whether we applaud it or not. And I want to read from Justice Kennedy's opinion. It is true that before today, this court has never held that non-citizens, remember, we're not talking about U.S. persons, detained by our government in territory over which another country maintains de jure sovereignty have any rights under our Constitution. Pretty clear. We recognize it. But we hold that Article 1, Section 9, Clause 2 of the Constitution has full effect at Guantanamo Bay. Third point, and I completely agree, the long legs of Korematsu. This really is an opinion, the majority opinion, is a great articulation of a vision of liberty in the face of a very serious claim of executive power. Both sides had some very strong arguments. But the fundamental point in a free society that is being made is that to detain someone without a judicial determination of guilt is a very serious matter indeed. Thirdly, for the law students, again, note the court's methodology. It is, once again, deeply historical, even though the historical materials don't yield up a clear answer. But nonetheless, notice that they go to the trouble of analyzing history, the role of habeas corpus, going back literally centuries. History is not only not bunk in the analysis of the Constitution and the great rights under the Constitution and the great structure of the Constitution, it is at a minimum quite relevant. Whether the Academy likes it or not, we all have to be, at least try to be serious avocational historians. Next, the decision really is, and so I will now echo comments that have been made about other cases, while it is mighty, it has great symbolic value, is limited entirely, by my lights, to Guantanamo. In other words, when Osama bin Laden is captured, the message is, please don't bring him to Gitmo, assuming that Gitmo still exists as of January 21, 2009. But this really is in the tradition of a very robust and muscular use of the judicial power in defense of liberty. There's a concern that seems to be understated somewhat, but it's articulated in this opinion, but it really is captured by Justice Jackson's iconic concurring opinion in the Steele seizure case. We all, if we've had constitutional law, remember his 3 categories of presidential power and his wonderful rhetoric, his ability to, as a relatively undereducated person, never graduated from college, had 1 year of formal legal training, just goes to show. Remember, you need to learn how to write, and Jackson knew how to write. But in the course of that remarkable opinion, he warned about emergency powers. And he returned to the founding and unashamedly embraced the founding and the unwillingness of the founding generation to create and grant emergency powers. Emergency powers may beget emergencies. And so that brings me to the other the other dimension and really my final point, which is, as important as this is a statement about the importance of human liberty, at least with respect to the articulation of the role of habeas corpus in a free society. What is not being drawn into question is really the underlying power that, what shall I say, is the elephant in the room, and that's the presidential use of military force. It was Arthur Schlesinger, the renowned historian, who claimed that from a constitutional perspective, Abraham Lincoln was a despot. He was a tyrant. And Mr. Lincoln acknowledged in letters that he violated the Constitution. Not that he stretched it, he violated it because he had to, as he saw it. Presidents have used military force without congressional authorization, according to the account of the distinguished Yale historian Eugene Rostow, over 200 times. Now, there was, of course, authorization here, but we can all wonder to the extent that we had time, how efficacious was that. And so this case is very important, but it really doesn't tell us about that which really ultimately counts now that we've had a rearticulation of liberty, and that is who controls the president's use of military power. It is clear in our history that Congress is unwilling to try to control the president.
Thank you. Judge Wick?
Well, this case is permeated with politics and political considerations, and I will give only brief comments. I echo Judge Starr that the practical application of this case appears to be limited to Guantanamo Bay. All of the combination of circumstances that come together to reach this conclusion for Guantanamo Bay don't seem like they would apply in any other military base or anywhere else. So that part of the case is narrow, but it has the appearance of a substantial cutting of the Gordian knot of case law that had been growing up and not dealt with, and to me it looks like an attempt to, or the beginning of a paradigm shift that's going to cash out in lower court proceedings to fill in the holes that are not addressed here. The court's rejection of a de jure formalism as to place reflects a flexible notion of habeas corpus. The case describes or evidences a variable assessment of the adequacy of underlying procedures and the effect they'll have on the scope of necessary habeas corpus procedures and habeas remedies. So I will rest with that and the conclusion that this is a doctrinally very significant case.
Thank you. Professor Marcus, did you want to say anything else, or should we go to questions? Do we have questions?
Dean Massaro and Judge Starr both noted that this is more aptly called the Kennedy Court than the Roberts Court. So I wanted to ask a question about that. Justice Kennedy was in the plurality in Hamdi, wrote a concurrence in Rasul, joined the majority and wrote a concurrence in Hamdan, and then, of course, wrote the majority opinion in Boumedienne. My question is, as long as this is the Kennedy Court, can we hope for any kind of coherence in the war on terror litigation?
I'm going to let you answer Andrew's question. He asked those kinds of questions to me in con law too, as well. Well, the simpler response is I do think it's difficult. I find it difficult personally, teaching con law, to predict, more difficult to predict what Justice Kennedy will do, and that's not just in the Guantanamo Bay cases by any stretch of the imagination. I don't know that that's necessarily a disability. You have the issue of people complaining about the court being political, and that you can tell how they're going to rule based on their politics. I think it's a little harder to predict what Kennedy's going to do based on an assumption about his politics. In terms of incoherence in the Guantanamo Bay area, I think it falls into the lap of Congress to do something about this. And instead of skating along the line, they could bring it in more narrowly to satisfy the limited objections that they had here, though they're fundamental ones. Right to counsel, sort of looking again at the hearsay, and then worrying about the competing interest, which is disclosing national security information to the enemy combatants. And so there's a solution. It just may not be the one that you like. In fact, it probably isn't.
I would add the voice of Professor Paul Gewirtz of the Yale Law School, not so much specifically about Justice Kennedy, but who talked about justices frequently are seeking what he calls the emotive core of the case. What, when you strip all the jargon away, is this case all about? And you should be able to explain it to someone who has never gone to law school and perhaps hasn't even completed her high school education. Explain it in simple language. And I think that what seems to animate Justice Kennedy is a sort of sagebrush rebellion belief in liberty and the skepticism about power. He certainly believes fervently in individual freedom of conscience. That's one of the things that really does unify him. He's somewhat, as you would expect someone from the West, to be very skeptical about power, very non-deferential to the exercise of power. Call him Barry Goldwater.
My question is, had there been another, let's say there was another attack on the scale of 9/11, maybe in 2006. My question is, how would that have impacted the decision here? Because it's been, 7 years since 9/11 happened, and life here is different than it was, September 12th, 2001. So how would that have made a difference if there was another attack on something?
If I could make a 30-second comment, Justice Kennedy talks specifically, it's a very insightful question. Justice Kennedy talks specifically about this is a different kind of conflict. It is so protracted. It is longer than any other conflict in which this nation has been engaged. And I believe that temporal open-endedness was of concern articulated by the court in terms of cabining executive power.
I think of a dinner party at Lawrence Friedman's house a long time ago, in which they were talking about someone who had recently passed away. And he said, and he's an historian, this fellow did the right thing under circumstances in which that subsequently people would conclude that was the right thing after the panic of the moment has receded again and again and again. And I think it is a marvelous, intractable question of how how judges in particular, but lawyers and citizens move toward that kind of wisdom in the face of the scariest moments that we live through, whether it's in our personal lives or on the higher level. And I think that's my point about the war on terror. This is unprecedented. Not terror, certainly, Haymarket riots, and terror is not new to us, but its pervasiveness and the staggering potential force of it is. I'm sure it would have affected how they thought about the case, where they affected the balance. That's the challenge, I think.
I have two answers. One is to think about it in terms of who would be bringing the cases. The detainees had an awfully difficult time. Well, they weren't even trying to get lawyers. They were on their own. But lawyers were not volunteering to take these cases in the wake of 9/11. The Center for Constitutional Rights, which brought the Rasul case, was the only one who was willing to take on these cases at the outset. simply put, the lawyers who ended up taking these cases pro bono, many of whom are members of fancy Wall Street firms and the like, weren't willing to sign on after 9/11. So it would be interesting to know what the dynamics would be in terms of representation if there were a continued series of attacks. That doesn't get at your question directly, but I think one way to think about it is how has the court responded in other times when there's been an ongoing conflict, a hot war, World War II, the Civil War. And I think if you look at how the court has acted in the Civil War as compared to the World War II, you see two different responses. In the Civil War, you had the justices, most of whom were appointed by, or all of whom were Southern, none of whom had been appointed by Lincoln yet, going crazy at Lincoln's assertions of executive power in the face of clear constitutional protections. In World War II, you had the justices, all of whom had been appointed by Roosevelt. I don't know if that's, or most of them had been appointed by Roosevelt, acquiescing in what Roosevelt was doing in conducting the war. So I don't know that there's a clear answer to the question, but I think that it's one of sort of real sort of politics and perhaps a little less one of principle or doctrine.
Any other questions?
I hope we have more of these public forums at the law school or the community town halls. And I hope that those of us who may be affected personally, like affected medical products, can have a chance to discuss some personal cases, how to deal with those legally afterward. I see a gentleman in the audience who's spoken out of the county and city governments called to the audience talking about sundry things. There's a case recently where the federal government, might have been from the CDC, Centers for Disease Control, permitted HIV patients to come in from other countries. Would they be considered aliens, and is there a chance of contagion? Could you comment a bit about that? And I thank you very much for your...
I think we'll try to aim our questions at the cases that we discussed today or more general questions about the Supreme Court. I think there's another hand up over here.
I was more curious why it seems like this case be so narrowly defined to Guantanamo Bay, because, I don't know, just my impression of it is it's just that. Isn't it just an incentive to not necessarily keep detainees there, but offshore, possibly in Iraq or in a military base in Europe or somewhere else? So is it really that narrowly defined, basically just telling them, just don't do it in our own backyard, find a new place to keep everyone?
I think we're in agreement on that point. That the consequence of it, that the wording, every way in which you look at the holding of the case suggests that it's about Guantanamo Bay. And yeah, the next move might be just that. It may produce perverse incentives.
Someone put it very well. Look, the United States has total control over Guantanamo because there are Burger Kings and McDonald's there. You get the idea. It's all U.S. property, even though formalistically, again, sovereignty has never been ceded from Cuba. But there really is no end in sight of U.S. The leasehold. And so it is the uniqueness of Guantanamo, which, of course, is one of the reasons Gitmo came into existence a long time ago as a place of detention.
Of course, that's just the holding, right? I mean, as I said, the optics of the case are different, and so to the extent that people are enthusiastic about the result, it may put political pressure on the U.S. government not to steer it away, though if we don't know about it, what can we do? But to the extent that we have developed an explicit policy with respect to enemy combatants, then of course it may have longer legs. It's like Korematsu, but we'll have to see what happens. I think all the panel is saying the narrow holding, and if you read it, the language is restricted to Guantanamo Bay. Do you disagree? Others?
Are there other questions over here?
Very quickly. There was some talk recently about permanent American installations in Iraq after we left. I don't know how that's going to go, but it does seem to me that if we ever do something like that, this may not be so easily limited to something like Guantanamo, and could be applied to something in Eastern Europe or something like that, or in Iraq.
Well, Justice Kennedy certainly looked at the totality of the circumstances, and he did this very interesting comparison, as you know, to the German facility that was at issue in Johnson v. Eisentrager, which was viewed once upon a time as the case that means that the detainees lose. Justice Jackson's somewhat Delphic opinion in that case. And I think you are onto something, that if in fact it becomes a, quote, permanent establishment, he would look at the treaty determinations over that it really is becoming, as it were, the United States in Iraq permanently, then Justice Kennedy, and he will carry the court with him under the current composition, might very well agree with you. Or might, I shouldn't say agree with you, but might very well conclude that the Constitution applies.
Other questions? All right.
Taken care of is the treatment of the prisoners, as was happening back in Iraq, the water, torture, and all that business, and what they had done to them in Guantanamo Bay using military power. I can understand not wanting to let these people get back out to do more, if they're bombing markets and things like that, whatever. So does that play into this decision? And I would understand that if this facet was not brought to the Supreme Court, they might not even consider it anyway. So.
Well, I think, again, it's both optics and the political meaning of the case and popular understanding of it. And it's hearkening back to every case is you have to ask what's the year of the opinion and what's going on. And one of the consequences of the opinion, I think, is this politicizing of the issue. And yes, I mean, Senator McCain has been very outspoken on that point and being opposed to those tactics being used at Guantanamo Bay, and Senator Obama as well. So, but does it actually govern the outcome in this case in any way that we can identify securely? I don't think so. Not as a legalistic matter, anyway.
At oral argument, I think in the Rasul case, I'm not sure which one, but one of the earlier cases, one of the justices asked the Solicitor General, well, if there really is no legal oversight at Guantanamo, what happens if you torture people? And the response from the Solicitor General was, we don't torture, trust us. And I think that we can have arguments about what's happening in Guantanamo, whether it's torture, whether it's not, so forth and so on. But I think that I'm quite confident, I would guess, not ever having been a Supreme Court justice, argued before the Supreme Court, or clerked before the Supreme Court, but I would guess that kind of consideration would be important, that there's a certain amount of credibility that the administration sacrificed when photos of potentially, one might describe as misconduct by American forces with respect to detainees surfaced. And I would guess that kind of consideration probably played some role in the way that the court at least approached this case, the frame of reference the court used to put this case in.
In fact, could I add on that one of my colleagues at Pepperdine, Professor Pushaw, has done this sort of panoramic, sort of a 2-year study, and one of the conclusions of the study of presidential power and the court's response is the court will step in when the president is weak. And I think President Truman's weakness at the time of the Korean conflict, or at the time, I should say, of the steel seizure, his relative political weakness may, in fact, be a contributing factor. Perhaps it's just a coincidence, but it is quite interesting that the court is more willing to step in when there is a weakened, or perceived to be a weakened, executive.
Well, thank you very much to all of our panelists today.